Item number 1.
Lordship, may I please your Lordship? I am for the petition. Lordship, I have been suspended. I am
When?
in charge
When?
on 6th April during the election period. Now I have been suspended without any so-called notice. I went before the administrative tribunal. Bench is not functional. I am only
Prior to suspension, under which provision a show cause is to be given?
no so-called has been
Under which provision there is a requirement of giving show cause prior to suspension?
under West Bengal.
Yes, show us which provision.
Let me appear tomorrow.
Tomorrow, not today.
I appear for
He has to complete. You have to wait.
item number 2.
Well, as yesterday, I had commenced my submissions and pointed out to your lordships that the petitioner had preferred a contempt in respect of the division bench in 2017. Well, as I just want to place that decision of contempt, well, as it hasn't been placed before your lordship as of yet. Your lordship will just kindly take.
See, ultimately, it is the tenor of the order passed by the division bench which is relevant.
Yes.
Whatever may have been said by the contempt court, your specific case is division bench said to consider,
Yes.
and that has been complied.
No, the reason why I want to cite the contempt order is because this position that the GC is not convening a meeting or the acquiescence to the GC's jurisdiction has been reiterated. Your lordship will just take page 133 for a moment, Malaj. This is volume 1, Malaj. Malaj will kindly take paragraph 2 onwards, if I may just place, if your lordships have it. 133, 134.
Yes.
Yes. Dr. Taposh Kumar Mondal, the petitioner appearing in person, submits that in spite of full knowledge of the judgment dated so-and-so, 29 June 2017, the alleged contemners have not taken any steps towards payment of arrear benefits to the petitioner consequent upon the promotion from Professor E to F awarded by the DPC from 1st February 2009 to 30th June 2010, the date of his superannuation and fixation of basic pension considering the new basic pay. The promotional benefits and consequential retirement benefits have also not been withheld. The contemners, Malaj will kindly note this sentence, the contemners deliberately and willfully did not convene a meeting of the Governing Council of Science Institute of Nuclear Physics, in short SINP, following the bylaws and did not take any steps towards grant of promotion to the petitioner, causing huge financial loss. So, well, as this is the second occasion on which he has essentially acquiesced to the jurisdiction of the GC. Well, as there's another judgment of contempt, I won't place that. Your lordship will just mark the page number.
Perhaps he has not argued that GC does not have a jurisdiction. What is saying that this option was not available to the GC to again send it for consideration before some other.
The academic subcommittee.
Yes.
Malaj, even that has been taken into account in the next paragraphs of this very order. Your lordships will see he further submits that the Governing Council only approves best the recommendation of the DPC. That's his submission. Malaj will kindly take paragraph 7 at page 136 onwards. Placing reliance upon the affidavits in opposition filed by the contemners, she so-and-so, the learned advocate for the alleged contemners, submits that in compliance with the judgment dated so-and-so, passed by this honorable court, the respondents have already paid a sum of rupees so-and-so to the petitioner on account of arrears. The petitioner is also receiving pension continuously and uninterruptedly as on date. In further compliance with the said judgment, the 117th meeting of the Governing Council of SINP was held on 3rd February 2018. The issue with regard to the petitioner's promotion was considered in the said meeting as mandated by the solemn judgment of so-and-so, and the same was referred to an ASC of the Governing Council. for its consideration and comments. The ASC, Malas will kindly note this at 137.
Yes,
The
you had
AS,
argued- yesterday you argued this.
yes, and this has been considered by the division bench on an earlier occasion as well. And your lordships, finally, the division bench, by way of this order, had disposed of the contempt, saying that there was no contempt that was found. Malas, that is my first point. Now, Malas, my submission therefore would be, as I pointed out yesterday, that it would tantamount to Malas, one, he has acquiesced to the jurisdiction of the GC. Today, if he raises a challenge to the question of whether or not the GC can consider the promotion at all, Malas, that would effectively tantamount to reviewing the decision of 29 June 2017. And that is not permissible, Malas. What can't be done directly cannot be done indirectly either. Malas, that is my submission in law in respect of this contention that my Revatsina has taken. Malas, to that extent, I just want to place one judgment, Malas. Suprateke judgment. Malas, this is 2023 volume 10 SCC 817. Malas will kindly take paragraph number 13. Malas, in this particular report, Malas, the Supreme Court was looking at the practice of filing miscellaneous and clarification or modification applications. And the Supreme Court held that that is not permissible. Under the guise of a clarification application, I can't review a judgment. Malas, in paragraph 13, the Supreme Court, Malas, will kindly see the last sentence. Reiterated the principle that what cannot be done directly cannot be done indirectly. Today in the event, Malas, even if, Malas, because I, insofar, on the last occasion when your lordship recorded the order, recording my revered senior submissions, a question of jurisdiction of the GC has been raised, including the delegation to the academic subcommittee. And as I pointed out to your lordship, the ASC is a body carved out within the GC itself.
Yes.
Malas, thereafter, Malas, yesterday I had shown the scope of an intra-court appeal. I had placed one judgment. Malas, I had also made a submission that if two particular views are possible and one view has been taken, that is not a ground to prefer an intra-court appeal. On that specific count, Malas, there is a Supreme Court judgment that I was able to find, Malas. We'll kindly see 2016 volume 3, SCC 340, Malas. Malas, will kindly take para 5 of this report. Malas, if I may just place. Once the learned single judge having seen the records, had come to the conclusion that the industry was not functioning after January 1995, there is no justification in entering a different finding without any further material before the division bench. The appellate bench ought to have noticed that the statement of MW3 is itself part of the evidence before the labor court, be that as it may, in an intra-court appeal. On a finding of fact, unless the appellate bench reaches a conclusion that the finding of the single judge is perverse, it shall not disturb the same. Merely because another view or a better view is possible, there should be no interference with or disturbance with the order passed by the learned single judge, unless both sides agree for a fairer approach on the relief. Now, my lords, a lot has been said about the recommendation that has been made by the selection committee and the binding nature of the same. Yesterday, my lords, I had made a submission that a recommendation is not binding or is not a mandate. My lords, to that extent, my lords, there is one decision, if I may place. This was placed before the single bench. There are several that were placed before the single bench. My lords, I'll just place one, which is Manohar versus State of Maharashtra. Manohar versus State. Manohar versus State of Maharashtra. This is reported in 2012, volume 13, SCC 14, Malads. Malas will just take para 14 of that judgment. Right, copy ache. Para 22 of that judgment, Malas. Malas, if I may just place it. We may notice that proviso to section so-and-so specifically contemplates that before imposing the penalty contemplated under so-and-so, the commission shall give a reasonable opportunity of being heard to the officer concerned. However, there is no such specific provision in relation to matters covered under section 20 subsection 2. Section 20 subsection 2 empowers the central or state. But as we'll kindly just go to the later sentences. Power to recommend. Your lordship has that?
Yes.
Yes. Power to recommend disciplinary action is a power exercise of which may impose penal consequences. When such a recommendation is received, the disciplinary authority would conduct the disciplinary proceedings in accordance with law and subject to satisfaction of the requirements of law. It is a recommendation and not a mandate to conduct an inquiry. Recommendation must be seen in contradistinction to direction or mandate. But recommendation itself vests the delinquent public information officer SPIO with consequences which are of serious nature and can ultimately produce prejudicial results, including misconduct with relevant service rules. So therefore, Malas, what I seek to highlight from here is that the recommendation is not a mandate that is binding on the GC. And that would be evident from the order that has been passed by the Honorable Division Bench, as well, the Coordinate Bench, which says that in the event the GC approves. Malas, thereafter, will kindly, Malas, the right of promotion not being a fundamental right, Malas, there's two more decisions I'll be placing before your lordship. Malas, Union of India versus Manpreet Singh. Reported in 2022, volume 6, SCC 105, Malas. Correct copy, acha. Malas will kindly mark paragraph number 14 of the report, Malas. Malas, paragraph 14 of the report, Malas. Malas, paragraph 14 of the report, Malas, highlighting the judgment of Ajay Kumar Shukla versus Arvind Rai, your lordship, the Supreme Court reiterated that right of promotion is not a fundamental right, Malas.
Only consideration.
Yes. And Malas, the last judgment that I'll be placing before your lordship is that a court cannot sit in appeal over the discretionary decision of the departmental promotion committee. Malas, the celebrated judgment of Anil Katiyar versus Union of India.
In 22.6 SCC, you are referring to which paragraph?
22.6 SCC, Malas, this is Manpreet Singh, Malas, para 14. Malas, Anil Katiyar's judgment, 1997, volume 1, SCC 280. Malas, I'm citing para 4 of the report. Having regard, Malas, if I may place.
So arbitrary or malified or...
Yes, that is the limited scope of interference. Here I pointed out to your lordship yesterday as well. This is a question of whether or not an individual, a candidate who is being considered from associate professor E to F as a biophysics professor. These are technicalities, Malas, which a writ court does not enter into. An arena which a writ court ordinarily does not enter into. Whether or not he has enough peer-reviewed journals or not. Malas, that an authority which is vested with the expertise on the matter would be the best to decide whether that is, the criteria in respect of the same are satisfied. And this is a merit-based promotion which is granted to the individual, Malas, not merely seniority-based. Malas, so these are my respectful submissions, Malas, and I reiterate the judgments that were also cited before the learned single bench, Malas, that will call it. Can you?
May I respond?
Malas, so far as KV Janki Ram's judgment, Malas, if I had to distinguish that, Malas, I'll just highlight one thing. In KV Janki Ram's judgment, Janki Raman, which my revered senior had placed. Whereas in that case, perhaps the individual, paragraph 10, Melas, which was placed before your lordship, whereas the officer before his case was placed in a seal cover was already promoted. He was perhaps already promoted, Melas.
No, he is not. He's relying on the judgment to say that once the sealed cover is open, whatever is in it has to be given effect.
Then,
But
Melas,
perhaps what he was.
then in that event, Melas, I'm trying to, then I'll reiterate, Melas, to countenance this, Melas, that a recommendation is not a mandate, Melas. I'll
We have
reiterate.
got that. Yes.
Yes, I'll reiterate. These are my submissions, Melas.
First of all, Millard, the first point, with deepest respect and humility, Millard, to my learned esteemed friend, Millard, that his understanding with regard to the acquiescence, Millard, is, Millard, inapplicable in this case because of the simple fact, Millard. The acquiescence is a concept which I have understood, subject to what my lord has said. The law gives a person certain right, knowing fully well, Millard, he has chosen not to avail of such right. So my silence here. Now, Millard, it is true and admitted, Millard, that Honorable Division Bench, in its wisdom, Millard, directed, Millard, the governing council to consider my case. The question is, Millard, whether it is a declaration of a final destination of a petitioner and his fate was sealed. With deepest respect and humility, Millard, the Division Bench has directed the GC to consider the case, Millard, with reference in accordance with law, because in law everything is with reference to context. Here the context is the rule which your lordships many a times insisted. Norms and the rules. Here, Millard, the term is you have to implement, because GC could have said in its wisdom that as per Rule 9, had it been an F2 higher post, I could have considered the director should be directed. He is the authority as per the norms that you are to consider. You are to implement Rule 812.
Yes.
Number one. Number two, Millard, that every consideration, Millard, possibly that the judgment here, Millard, it is not a case that I am seeking the honorable. I am seeking, Millard, that my case should be considered. Here, Millard, consideration has been made. It is a question of implementation. Had it been a case, the director placed this matter in terms of Rule 9 to the governing council, and governing council must act upon it, that two situations are different. Number two. Number three, Millard, my learned esteemed friends understanding with 2023 judgment, which says, Millard, the application for clarification and or modification is not maintainable. That judgment was a declaration of law with regard to a factual matrix where, Millard, the petition or the SLP was disposed of. In this case, Millard, my application CAN 15977, which was shown to your lordship yesterday, Millard, this is not in the nature of such application which was filed after the disposal. On the contrary, this application was taken up for consideration by the Honorable Single Judge. The Honorable Single Judge, page 6021, paragraph 3, the first sentence, I am indebted to my learned friends for his meaningful assistance to the lease between the parties, while he says, my lord, that the Honorable Single Judge matters can be only interfered with in an intra-court appeal where there is a perversity. In this case, the Honorable Single Judge did not consider the records or the materials placed before her ladyship in its proper perspective. Nothing can be decided, my lord, beyond the scope of the rule. They are bound by the rule. They don't travel beyond the rule. In this case, if the words are implementation, matter ends. Janaki Ram has been implemented by way of, my lord, 14th September 1992. Paragraph 3, page 79, I have shown. Page 51, 52 of your lordship's brief, it delineates, my lord, the entire trajectory, how the authority will proceed. There is no ambiguity. Your lordship's mind, not at any point of time, were clouded, my lord, by reason of such enigma or mystery that the legislature or the executives were not very much sure of their own action. On the contrary, the legislature has compartmentalized the right of promotion, right of consideration into different aspects, which, my lord, denotes the clarity of thoughts. From D to E, different compartment. F to a higher post, different compartment. Today, the further consideration means the consideration in context of rules. Today, my lord, he cannot be a person who can be allowed to, by reason of his poetic imagination, to supplant something which ultimately demolishes the edifices of the entire norms. It is, my lord, a kind of a destruction of entire administrative fulcrum. It would create a class amongst the class. So his conception is a teasing illusion. And my lord, that is my understanding. And 113 and 143 and
So
40
based on a misconception of the norms.
norms.
Therefore, it is amenable to the intra-court appeal.
The intra-court appeal is perverse. I said, Governing Council, this was kept in a sealed cover. Governing Council, after Millard opening this, they should have said in
That you
terms
have already said that once
he
it was
said
open.
that the Governing Council, as per the division, where is the element or the morsel of proof? On the contrary, page 113, what was the submission made before the division bench, which induced the division bench to believe that this would be the correct procedure? Kindly see, we requested Mr. Mantha to avail instruction as to whether the said institute was desirous of dropping the proceedings. Upon availing necessary instruction, Mr. Mantha states that the authority should not be weighed to the order of punishment and that the promotion as sought for by the petitioner had also been placed before the governing council, which would pass appropriate order. The terms appropriate order, it means the order to be passed in an appropriate manner with reference to context in the context of
That
rules.
point you have already made.
Yes, no appropriate order.
Yes.
It is not a blanket order that whatever may be the rule, you have to not reject.
That point you just argued prior to this point.
I was nervous. That is why the tiring repetition. And Millard, so the judgments, Millard, which we have shown, Millard, it may have been the best preparation for the other cases, but not on the proposition of law or the factual matter before Millard. In this case, with deepest respect, Millard, he said the back wages entitlement to 2016 3 SCC, page Millard 340. Millard, the consideration of back wages has also been, Millard, enunciated in page 79, 14 September 1992. The question of back wages, Millard, in paragraph 4.5 thereof, Millard, indicates once the promotion has been implemented, the back wages part is to be considered. There is a chance or scope, Millard, for opening the issue. Whether in the present context, back wages can be considered. The executives, Millard, thought fit and proper, relying on Janaki Ram paragraph 10, that back wages part to be reopened. So, Millard, this
both of you are referring to Janaki Raman as Janaki Ram.
Janaki Ram.
It is Janaki Raman.
Raman. Janaki Raman. Sorry, Millard.
Sincerely apologize.
1991.
I made that
1991.
Supreme Court 2010.
Janaki Ram, I said, no?
Ah.
But I'm obsessed with Ram.
I know. That's why I said both of you are saying that.
What can we have surrendered to the climate, Millard. Now, Millard, kindly, Millard, have the charity to consider that today my right flows from, Millard, the rule. Today, my consideration part, once it is over, there is no question of exercising discretion.
Yes.
So, Millard, my respectful submission, the judgments which my learned friend relied
Not applicable.
not applicable, and acquiescence, Millard, does not come because I have never relinquished my personal right, and there can be no estoppel against law. If law gives me a right, and I am not, so my repetition may kindly be allowed. May I take my lord's kind leave? I am deeply obliged for your lordship's patience.
For a patient hearing, there is just one point I just wanted. I'm not going to
Learned
reiterate anything.
advocates have made their submissions.
My lord, I am for the respondent number 1 in this case, Union
Number 1.
Union of India, and in the order dated 5th May, our name has not been put in the order. Kindly, my lord, reconsider this.
Which order?
5th May. 5th May order.
Did you give an appearance on that day?
Yes, my lord.
We are informed by the learned advocate. Yes.
Item number 3.
Yes.
Item number 4.
For the petitioner, who is the respondent?
Item number 5. Mr. Mukherjee is on our website.
After holidays. Same on.
Item number 6.
Thanks, my lord. Sure, my lord. Mr. Mukherjee is.
Same order.
Item number 7.
No, 7, who is for the petitioner? Oh, as paid by learned advocate for the petition.
Item number 8.
None for the writ, none appears for the writ petitioner.
Item number 9.
But on behalf of Srijani Mukherjee, who is appearing for the petitioner, I'm praying for not to be.
Noted.
And for the petitioner, I have a choice.
We'll have to adjourn this anyway. So it is only for citing the judgment today.
I,
174.
This was, yes, your lordship. This was the question that fell from your lordships. I have found, lordship, two notifications of the central government, your lordship, not the state government, which says that died in harness includes if it is death by suicide as well. One notification is of 1998 when the petitioner died, your lordship, and another is a very recent one, 2022.
When the death occurred?
Lordship. 1998, your lordship.
So 1998, your father,
Yes, your lordship.
he passed away by, it was not a natural death, it was a suicide.
Suicide, your lordship.
You
Due to
filed,
pressure and
so you filed an OA in 2015.
before that, I had my mother, because I was a minor at the time of my father's death, my mother had applied, your lordship. Thereafter, no, my mother's application was rejected, your lordship.
When?
In 1998, we had applied.
When it was rejected?
Lordship, that is not there, but my...
Therefore, the point remains that you made an application before the tribunal in 2015. The tribunals give you a liberty to file a representation.
Yes, your lordship.
So, by virtue of such an order, can that order breathe life into an otherwise stale or dead cause? That is the first issue. Then an issue would arise whether the suicide can be treated. So, first you have to get over this. We have recorded in the last order.
Yes, your lordship.
So 98 to 2015, how many decades?
Lordship, in the first paragraph of Lordship's last order, it was stated it is not open to the respondents to contend that the application was belated. As per my application.
That is your submission. That's not the court's observation.
Lordship.
That is your submission. Please read it entirely.
Yes,
Don't
yes,
read a line from here and there. That's not the way to place an order. That's not expected also. You are to lead us, not otherwise.
I'm on the point, your lordship. My first OA was allowed, your lordship.
Where is the order allowing your first OA?
Lordship, the rejection order was set aside. It is at page 53, your lordship. The operative part is at page 55.
When did you make your application, which was
my first application was in 2014, your lordship.
Before the subtenant?
Yes, your lordship.
Where is that?
That is at page 46, your lordship, before the private secretary, chief minister of West Bengal, lordship.
27/6/14. So could this be entertained after 98?
Lordship, there is a lot of delay, your lordship, but initially my mother had made 2 applications, your lordship. That was not considered, your lordship. Your lordship kindly comes to page 41. That is my mother's first application.
No, she never applied. She applied saying that when he becomes a major, you give him a job. She never applied. So she was not in distress. She said, I can wait till he attains majority. And when did you attain majority?
(2014) itself, I believe. No, I attained majority in 2008, your lordship, but I was studying at that point of time, so I wanted to complete my graduation and then...
Very good. That's all?
Yes.
Which judgment you want to cite? Show us.
Lordship, right now
Then we are finally deciding matters. Heard the learned advocate.
Item number 10,
Records and everything is complete.
Yes. My learned friend has already supplied the paper book
on the last occasion.
for the last occasion. As per your lordship's kind direction.
Something regarding some emoluments linked to an area.
Promotion.
City, something.
The point in issue is very short, lordship. After applying for the promotion as per the promotion policy and subsequent notification issued by the appellant before your lordship, and with his eyes open, after not meeting the criteria, whether my learned friend's client can resile from the or challenge
The terms and conditions under which he sought a benefit. That is your submission.
That's my submission, lordship.
So which is that terms and conditions? Let us come straight to that.
Yes. Lordship, kindly take the trouble to consider annexure page 35. My promotion policy. National Insurance Company Limited promotion policy for promotion of inspector grade 1 to the cadre of assistant administrative officer. It has been decided to have an uniform and well defined policy for promotion of the inspector grade 1 in the cadre of assistant administrative officer, hereinafter referred to as assistant administrative officer. The promotion policy shall come into effect with effect from 1/1/1990. The relevant clause before, if your lordship kindly take the trouble, page 38, 11. When the advertisement was made, in deference to this clause, clause 11, if your lordship kindly take.
Why do you file like this? Why do you file like this? Want to make it convenient or you want to make it difficult? 35, then page 37. Then page 35 again. Then again page 38. Where is 36? 35 has been annexed twice, not in sync, not in order. We don't know about your paper book. After 35, it is 37.
The same problem is there, lordship.
And then after 35, again 35, 37, again 35. And then 38. We are not entitled to see the entire document.
The entire document, lordship, maybe the pagination, there is some difficulty. Your lordship.
Oh, where is 36? Where is page 36?
Lordship, I beg to be excused. It is wrongly numbered. If your lordship kindly consider 35,
Yes.
it is ended
SK
with
set.
3. Then 37 starts with 4. Maybe some
There is some mistake might out there in the paper.
pagination. 3 is the last column, the promoting authority. If your lordship kindly take that.
Below the rank of manager.
Below
Yes, below the rank of manager.
below the rank of
Manager.
general manager. Then lordship, if your lordship kindly take the trouble, 37, maybe wrongly, lordship.
No, this first 35 Is the first 35 is not complete.
First 35 is subject to lordship.
25 January 1980.
25 January 1980. Yes, 25 January 1980. It is the document.
Yeah, two different documents.
No, this is one document.
In that case, my lord, may I just very humbly submit to your lordship? Kindly grants me a time to.
No, no, let us try. Let us see. Let us make an endeavor. It is being adjourned too many times.
This is for the second 35.
No,
which
just please.
Yes.
The first page 35 bears a date 25/1/1980. At the bottom, it is bearing a signature of some authority.
This is the complete one. This is the circular after the promotion policy has been promulgated. 35 lordship, the wrongly number 35 lordship, kindly take the trouble.
Yes.
It should have been 36.
Yes.
It's the promotion policy shall be with shall come with effect from 1/1/1980.
Yes.
The first paragraph.
Yes.
I have troubled your lordship with
Yes.
this.
Yes.
This is this page. Item number serial number 3 is there.
So therefore, this page, second 35 and first 35 are at variance.
Yes, those the numbers are different, lordship.
No, it is a different document altogether.
Absolutely, absolutely. This is a promotion policy. Thereafter, and a circular has been issued
So
by.
which one you are relying upon?
I am first troubling your lordship with the second 35, which is the promotion policy.
Okay.
It has come to effect with effect from 1/1/1980.
Therefore, you say 1, 2, 3 is there at that page, and 4 onwards is at the prior page.
Prior page is the 4 onwards. 4, 5, 6, 7, 8.
And then the last page is at 38. All right. Yes. So let us.
I may be excused, lordship. This some pagination problem is there. And if you lordship kindly consider page 38, clause 11. These are the conditions of eligibility. Right now, I will not trouble your lordship. This eligibility clause starts from 11A to 11E, page 40. 11A to page 40.
Page 40.
Page 40.
Yes.
I will just trouble your lordship. Page 39, clause, the last clause, it speaks about the schedule premium income. This is the point to be considered, nothing else. Premium income procured during the year such and such, immediately of the preceding the year in which the promotion.
So there is a minimum prescribed. This you have to, according to you, this is a prerequisite.
This is a prerequisite as per the city.
Yes.
As the city, inspectors operating at Bombay, Calcutta, Madras, Delhi. Then B is A-class cities other than those referred to in A above. Then B1 class cities and B2 cities. These are the criteria. So,
and for all other cities, it is at the bottom.
At the bottom, we are not concerned with.
So no area is left untouched. For every area, there is a minimum business required to be procured by the inspector.
Yes. Now let's see. Now,
according to you, he falls in which?
He falls in A because agglomeration. The word has been used by agglomeration. This I will trouble your lordship from correct 35. Correct page number 35. Which your lordship has just now seen 25th January 1980.
Yes.
After promulgation of the promotion policy, management has issued this letter. This circular. Re-promotion policy for the promotion of inspector grade 1 to the cadet to the assistant administrative officer. The promotion policy for the promotion of the inspector grade 1 to the cadre of assistant administrative officer as set out in the annexure A has come to effect with effect from 1/1/1980. It is clarified that A, B1 and B2 cities, B2 class cities referred to the promotion policy are the cities declared as such by the central government from time to time for payment of city compensatory allowance to their employees. Now, if your lordship kindly take the trouble to consider page 32. This is his application. May I trouble you, lords? Page 32. This is his application for promotion, where he has admitted that his office comes under Calcutta jurisdiction. Lordship, kindly take the trouble. With reference to your circular number such and such, dated 25th July 1985, I hereby apply for promotion to the cadre of the Assistant Administrative Officer from Inspector Grade 1, giving below the particulars required under paragraph 11, subpara A to E of the promotion policy. I troubled your lordship over the promotion policy, page 39 and 40 criteria. Now, lordship, kindly consider name. My learned friend's client's name is there. Then 2, division, branch attached to Calcutta Division 15. Calcutta Division 15. Area of operation, Chandannagar branch, Pandua. From FRS, the government, FRS, as for FRS, Chandannagar, as your lordship knows, it falls within Hooghly district of the state of West Bengal. This comes within the city agglomeration. Lordship, kindly, this is the government, central government circular, and it deals with it from FRSR. FRSR Part 5, HRA and CC.
So Chandannagar falls in B or B1 or A?
It falls within, my respective submission is A, because agglomeration, Calcutta agglomeration city. I have given the FRSL, lordship, part 5. Lordship, I have only 2 copies. I beseech you, lordship, my lord. Hooghly, Chandannagar falls within Hooghly. district of Hooghly, and the employees of the central government, they are entitled to get the city compensatory allowance as a city which falls within the category A. And this
From
is
where do you get that? Which page?
let's kindly consider
Acha. Okay.
the flag portion. Let's see.
Yes.
Kindly excuse me, the portion is marked. 53, it starts with Constitution of Urban Agglomerations, 1991 census. And it takes us to 154, if your lordship kindly take the trouble. In West Bengal, Hooghly Chinsuda, it falls.
No, how do you say it is part of Calcutta or Kolkata?
The city, Calcutta city is
It says
falls under A.
it says Chandanagar Hooghly district at serial 17.
Yes.
So how can it be in A? A is only Bombay, Calcutta, Madras and Delhi.
Then A is within this A category city. Now central government decided to give the city area, extended the city area while giving the city compensatory allowances.
City compensatory allowance is not relevant for Bombay, Calcutta, Madras and Delhi.
It has been extended to certain other cities, which
That's
for
not the point. The point is he has made an application as a person operating at Chandanagar. Whether Chandanagar falls in A, B or C, that's the only thing. There is no other thing that is required to be seen. Because if it falls in A, he is required to procure the business, minimum business specified in A. If it falls in A class, then the next, number 2. Or B1 class, then also the next. And all other cities, 4 lakhs. So you are saying he is required to have a minimum of how much?
for A,
No, how much?
it is 8 lakhs and 6 lakhs. Page 40.
But admittedly, he is not in Calcutta. So how can you require him to have this business?
That's why, Lordship, I rightly or wrongly, and a circular has been issued after promulgation of the promotion policy, which is page 31. 35 I have shown before your Lordship on 25th January 1980. Yeah, how it is to be, how we consider this thing. And this is not under challenge either before the writ application.
31 you did not place, you placed.
35.
Yes, 35 you have placed. Yes.
35. The correct 35. It is clarified that A, B1, B2 cities referred to the promotion policies are the cities declared as such by the central government time to time for payment of city compensatory allowance to its employees. So the person who are living or working.
But sir, neither A nor B1 nor B2 falls within Bombay, Calcutta, Madras or Delhi. Because A is in, you come to page 40.
Yes.
A is in the second one, 6 lakhs. It is not Bombay, Calcutta, Delhi, Madras. A class city is in the number 2, in B, capital B.
A class cities other than those referred in A.
Yes.
Above B1 cities are B2 cities.
So therefore, there is the 4 cities are specified. Then there is an A class which is other than these 4 cities. And then there is a B1 class which is also referred to, which is having the same requirement. And the last is all other cities. So these 4 cities class form a class of their own.
Of their own.
And then comes A class cities, which are the cities other than the above 4, but where city compensatory allowance is being paid.
As urban, as an urban.
No, that is nowhere. That is nowhere.
No.
That is nowhere.
That is
agglomeration is nowhere.
Is there in the FRSR.
It may be, but this talks only of the cities. It talks of cities of operation. It does not talk of an area or agglomeration. It is very specific. It does not introduce such ambiguity. It leaves it very definite that these four cities form a class of their own.
Yes.
In B, there is a categorization of A class city, which are other than the above four. So there is no confusion whether it is part of an agglomeration or not. It says in bracket other than those referred to in A. A is Bombay, Calcutta, Madras and Delhi. Then there is a above B1 class cities and B2 class cities. So all these three are clubbed together. A, B1 and B2. The persons who are operating in that area, they have to have a business of 6 lakhs in the preceding year and 4.5 years as an average of the past 5 years. The last is any other city. We are not concerned with that. One, we are not concerned with. It's nobody's case that he is posted in Bombay, Calcutta, Madras.
That's why I trouble you also with 35. It speaks about, it is clarified after the promotion policy has been promulgated.
What is, please read 35 slowly.
It is clarified
Yes.
that A, B1 and B2 class cities.
A, B1 and B2 class cities. It is not referring to this clause A, B and C. It is referring to the class of cities, and A, B1 and B2 class cities are in the second categorization. Even A is in the second categorization. A is the cities other than those in A at page 40. So it does not, that A does not refer to Bombay, Calcutta, Madras and Delhi. It does not.
A class cities other than those referred to
In A above.
A above.
So those four cities form a class of their own. These four cities are in a class of their own. They are neither class A, they are neither class B, they are neither class P1. They are by name, they form a class of their own. They are not categorized in any category A, B or B1. A1 categorization appears for the first time in B at page 40, which says cities where compensatory allowance is being paid other than Bombay, Calcutta, Madras and Delhi.
Since
A clear. What the single judge has said?
Yes.
Let us see.
Before taking to the let us single judge order, may I place his representation that he also knows.
You just placed it. You have just placed it.
No, his representation I have not placed.
Yes, yes, at page 32.
32 is
Calcutta Division 15.
His application.
Yes.
Thereafter, when his candidature has not been considered.
And if in his application he says, I'm in an other city and I'm liable to only 4 lakh, will you take it? His representation means nothing. It has to be governed by the circular.
No, his representation speaks about 45. My second circular of 25th January 1980, because
we are saying is,
yes,
if in his representation he says that I am liable to procure only 4 lakhs because I'm in the category C, then will you accept it?
No.
You will not. So what he says is hardly relevant. You have to see with what is his place of posting, and the place where he is posted will determine the business which is required to give you. What he says in his representation, what you ask him to do is irrelevant. It will have to be governed by the promotion policy.
My respectful submission.
So therefore, there is no question of what he says, how it will determine what is required.
My respectful submission subject to Lordship and approval that so far as promotion policy is concerned, it has to be read in conjunction with the next notification of 25.
No difficulty, no difficulty.
If that be the situation, that's why I will trouble your Lordship with page 58 only once. Because he knows agglomeration factor and he has enjoyed the money. Now he cannot turn around, then say, first paragraph, I became extremely surprised to know from the headquarters development department that my name has not been published in the ranking list as my place of posting has been changed from Pandua to Chinsura, which is now declared as Calcutta and urban agglomeration area, and therefore my candidature is not eligible for the consideration of the promotion. So
So he's saying, I'm surprised that you are doing this. He is not admitting to it. You read it in the context.
what
It's
I'm
not an admission whatsoever.
trying to say
He's saying, I am surprised
No,
that
no,
you are placing me in an agglomeration and therefore you are asking me to give such a business.
promotion policy.
There's no admission. You said he admitted. He is expressing surprise at how you are doing this.
So my respectful submission is
Yes.
He-
Let's
he-
see the anything else.
the agglomeration.
No, he did not. This is not an admission by any stretch of imagination.
He never
There is no admission. We are again giving you an opportunity. If you show an admission, show it now. We are very clear. We are observing openly that we don't consider this as an admission. If there is an admission anywhere, you may show it. It will be preposterous to hold this as an admission. He is expressing surprise at how are you doing this. Let's see if there is any admission.
a person, may respectful submission, a person who is enjoying the CCA on the basis of urban agglomeration. He never said.
You have said that, but you said he admitted. We are asking you again, is there any admission apart from this?
No,
We don't find this as an admission. We are saying it right here in court.
Yes.
Before we decide the issue.
Yes.
This cannot by any stretch of imagination be considered as an admission. He's saying, I became extremely surprised that you are treating me like this, as if I am part of an agglomeration. He's not saying that I am part of an agglomeration.
But my circular says that
that we have don't repeat. We have seen your circular. We have seen your circular.
Yes.
We have seen the subsequent letter clarifying that circular. We have seen his application form. Now you say the admission also we have seen. According to you, whatever is an admission. But we are still unable to find out from where this agglomeration concept has been introduced. Because neither your policy says, nor there is any provision otherwise shown regarding an agglomeration. The policy is very clear that if a city compensatory allowance is being placed at the area of his operation, that is the word used, you come to it, you see, then he will fall either in A, B1 or B2. If he is not in any place where that city compensatory allowance is being paid, he will not fall in A, B1 or B2. So is city compensatory allowance being paid in Chandan Nagar? Is it being paid?
He has received it. He has enjoyed it. City compensatory allowance.
We are not asking what he has taken. We are asking what is due. According to you, you are the employer. Is he entitled to city compensatory allowance at Chandan Nagar? You tell us. Where have you said? If he is that, then you show us that you have paid him city compensatory allowance. Otherwise, pay him today.
Just Lordship, kindly take the trouble to consider 118, the affidavit in reply of what my learned friend's client filed before the Honorable Court.
No, we are asking you in which pleading you have made an avowment that he is getting the city compensatory allowance.
He himself has said in reply, Lordship. Kindly take the trouble, 126, 2 page, 126, his reply. And these two things I got, Lordship. Page 126, para 6. With further reference to the said paragraphs, to the said paragraph 4 of the affidavit is my affidavit in opposition. I say that the fact that the petitioner never raised any protest to his receiving compensatory allowances is of no significance for the purpose of disposal of the instant writ application. So, and hence the allegation of suppression of the fact in the writ application is immaterial and has been the second portion, if you Lordship kindly take the trouble. Page 130. Page 130.
According to the writ petitioner, he is liable to return a business of 6.
Yes, according to him it's 6.
Very well.
Mine is 8.
Yes. No, yours we have seen. We are asking according
Yes,
to
absolutely. And page 78, if your Lordship kindly take the trouble, my affidavit in opposition, then I will again trouble your Lordship with 130, the reply what my learned friend's client has given.
78.
Page 78, Lordship.
Yes.
M. That according to the central government decisions, Chandanagar and Chinchura were treated as forming a part of the Calcutta agglomeration, and as such, the city compensatory allowance was also paid by the company to its employees posted at those two places at the same rate as at Calcutta. The writ petitioner who was posted at Chinchura under the Chandanagar branch and is still posted there is also being paid the allowance along with his salary effective from the date of opening of the branch of Chandanagar and his date of posting. The petitioner never raised any protest to his receiving such payment but has suppressed. So my learned friend's client in page 136 has dealt with this, admitting, and he has said it is not a case of suppression. Now, your Lordship, kindly take the trouble, 130, another place.
136.
130, Lordship.
130.
Prior to that, 126 I have shown before your Lordship.
Yes.
Now 130. Just middle portion. I say that, has your Lordship got? I am not troubling with your Lordship with the other portion because all have been the replica of page 3940. I say that Chinsura admittedly is a constituent of Calcutta urban agglomeration. The central government has declared Calcutta urban agglomeration as an A class city with a where the city compensatory allowance admissible to the central government. So admission, what has fallen from
Where is this declaration? We are still unable, at least I am unable to understand any such a declaration.
this is the chapter
So just a minute, please let us read together.
it may not tell you because I'm just
Constituents of urban agglomeration census.
census 1991 census.
Yes, 1981.
This is 81 year lordship. This is 1991 also. The same thing is there.
So which one we are to refer to? This is a promotion process of which year?
This is the policy of 19.
No, the process of promotion is of which year?
1985.
So 91 will apply.
So that's what the same thing is there. Just lordship,
as shown in table 2 of Census of India 81 series. Final population totals read with annexure thereto. So how is this relevant? This is just a part of the census, 81 census, and that is part of 91 census.
where it says
No, if it is
urban agglomeration, it comes within the.
No. This is for the purpose of census. They have
on that basis, lordship, the urban agglomeration has been declared, identified.
So
based
what?
Based on which city compensatory allowances are being paid
As class A city.
As class A.
Very good.
And that's why
he is not disputing that he is not in class A city. He has never disputed.
He is also enjoying that.
Why not?
City compensatory allowance.
Why not? Have you recovered it from him? Then it is due to him.
Yes, we have. We are not. We never join an issue over that.
Correct.
There is no question because my next.
He is also not joining an issue with you that he is not in a class A city.
And he is enjoying that.
Yes, and we are also of that view that he is in a class A city.
And that's why, lordship. 25th.
Yeah, we are agreeing with that, your submission.
25th January.
That he is in a class A city.
25th January 1980. 25th January 1980, page 35. I have troubled you.
Therefore, we are saying,
yes,
we are agreeing that he is in a class A city. He is also agreeing that he is in a class A city.
Yes.
But if he is in a class A city, how he will liable for 8 lakh rupees? That is where you are in some difficulty. He cannot be. Class A is below Delhi, Calcutta, Bombay, Madras. That is not in that. It cannot be read like that. So let's see what the Honorable Single Judge has held.
150 starts with 151. I will trouble your lordship with 157. Prior to that, the facts are stated. 156, your lordship will find that criteria, financial criteria. Then Dr. Such and Such appearing on behalf of, may I please?
Please.
157.
Yes.
Dr. Such and Such appearing on behalf of the insurance company submitted that A class cities have been classified as Hyderabad urban agglomeration, Delhi urban agglomeration, Ahmedabad urban agglomeration, Bangalore urban agglomeration, Calcutta urban agglomeration. Such and Such submitted that.
Same thing.
Such and Such submitted that the central government declaration has clearly mentioned that an urban agglomeration is made up for the main town together with the adjoining areas of the urban growth and is treated as an urban spread. It was further submitted that the distinction between distinction between the classification of the cities and the constituents of the classified cities should be borne in mind. Calcutta urban agglomeration has been classified as a city, and the Calcutta Municipal Corporation and Chinchura along with other places only. Constituents of Calcutta urban agglomeration and are included in A cities, A-class cities. Dr. Sachin Sach submitted that Chinchura comes with under an A-class city and under A as noted above. And since the petitioner's performance was not to the extent as indicated under A, namely rupees 8 lakhs to 6 lakhs, in two preceding years, the petitioner is not entitled to the benefit. Now, this contention has been quoted. Now, let's see 159.
158, second paragraph, read.
The contention on behalf of the insurance company, however, cannot be accepted. The inspector operating at Bombay, Calcutta, Madras, and New Delhi
have been separately. This is what we were also observing. That's a separate class. That has nothing to do with class A. That has been held by the learned Singh. Exactly what we were observing. The same thing. It goes on to explain why, and we don't know whether we could explain better than this.
I'm not. These are 87 lordship, whatever is there on that basis, I'm trying my humble bit.
We understand your endeavor.
I am trying my.
At least speaking for myself, I have a tendency of being very clear during the court proceedings, so that you know that you have to show something more. If you want, you can. But this is exactly what we were discussing. The moment you showed the policy, it is as clear as daylight. There are 4 cities forming a class of their own. Then there is a next, which is in B, but says class A cities other than these 4 above. Then there is B1, then there is B2. That is all guided by the compensatory allowance.
May I submit only one thing, subject to lordship kind approval. May I make my endeavor before your lordship from the prayer made in the writ application?
Yes, let's see.
My learned friend, from that, this will be my endeavor before your lordship to show that my learned friend's client has also understood the way we have understood.
Where is the prayer?
Lordship, page 19.
20?
19 or 20 starts with. Yes, 20 is the main.
Yes.
B. A declaration made by this honorable court that the petitioner is eligible for promotion as such and such to the cadre such and such in terms of the policy having annexed B. A writ and stroke in the nature of certiorari be issued directing the respondents to show cause as to why the circular dated 26th October 1986, omitting the name, there is the list, select list. This is there. Now D, writ and stroke in the nature of mandamus be issued commending the respondents and cash one of them, each one of them and their servants, agents, assigns to forthwith act in accordance with the law and forbear from taking any action pursuant to the select list. This is the select list. Then, very interesting prayer has been made, lordship, kindly consider. F, in the event, may trouble your lordship, page 21. In the event, it is contended by the respondent authorities that the petitioner is not eligible for consideration for promotion, in as much as the petitioner has been transferred from Pandua to Chinchura, which is now declared as Calcutta urban agglomeration area, falling under table A of paragraph such and such, that state transfer order of 78 to be withdrawn. My respectful submission before your lordship, nowhere the circular which is troubling my learned friend or based on which the entire thing has been done, 25th January 1980, page 35, is under challenge. Is under challenge before this honorable court.
No.
25th. No, it is not under challenge. That's why.
Yes.
It is not under challenge. Page 35, where rightly or wrongly the appellant before
What
your
is
lordship has done
the what is the date of the promotion policy?
1980.
No, that is a clarification.
No, 1980. Promotion policy we start from 1/1/1980. Page 35. Wrong 35, lordship. Promotion policy shall come into effect from 1/1/1980. The first paragraph.
But the same thing is stated in the second 35 also.
So second 35 has said it is the dated 25th January 1980. Right hand side top, lordship. If your lordship kindly take the trouble. Has your lordship
We
got it?
can't find it. No, this is the first 35, sir. This
Sir,
is,
I beg your pardon. lordship.
we are looking at the second 35. What
Second
is that?
35 is the promotion policy.
What is the date?
It comes with effect from 1/1/80. It is written.
That we are saying that the date of effect is one and the same, but what is the date of the document? Maybe at the last, see,
I'm just
at the end of
trying
that.
to. I'm trying to find it. Thing is there, lordship. It has come to effect from 1/1/80. It is written.
So which one is prior? The first 35 or second 35? Obviously, second 35 is
It's
prior.
the prior one, and based on this, the first 35 has been issued.
Obviously, because
It has got
came
a
into
reference there.
effect on 1/1/80
Yes, it has
and
got a-
clarification was issued on 25/1/80,
Absolutely.
24 days thereafter.
Yes, that's why, lordship. And my learned friend's client,
So what do we refer to it as? As a document dated what? That we are trying to understand.
this was the Annex G in the prayer, lordship.
Second 35. What is that document dated?
Section 35, lordship, the promotion policy for the promotion of the inspector. It is written there.
Much we are reading, we are trying to decipher what is the date.
Date is, lordship, is in that event I have to take.
No, not required because it says 23rd September 78 in prayer F, which you have read. Where is this 23rd September?
That is the transfer letter. I'm just showing it. If your lordship wants that document to look into, I'm just placing it. Page 35.
That's at page 35.
Sorry, 25, lordship. I'm really stuck between wrong 35 and right 35, and every time it is 5 is there. 25, lordship.
It
Kindly
is-
take that.
It is your creation.
25. This is the transfer order. He wants this thing to be withdrawn. May I put a question to myself, lordship? Your lordship has.
Yes, he says if you want to treat it treat it as if I'm in Calcutta, then you please withdraw it.
Yes, in a promotion policy, in a case of promotion, when these things have been
But
done.
this relief has not been granted to him.
Which one?
This relief was not granted.
He has been given the entire one.
Yes.
He has been given the entire one, where 25th January 1980 was not under challenge. Was not under challenge, lordship. And once he has, and page 32, which clearly shows that.
Sir, there is as large as you may try to make it. The issue remains only whether he will fall in A, B, or C. There is nothing else. So A, B, and C, which he will fall. That's all. He is not disputing that the policy does not apply. It is not your case that he is not in Chandranagar. It is neither of your case that both are ad idem that yes, he is getting a city compensatory allowance. So there is no dispute on these facts. despite these facts, can he be placed in A? That is the only thing. Or he is entitled to be considered as A class city falling in B of your policy. That is the only thing. There's nothing else.
It is,
Everything else is admitted.
yes, we have tried to canvass before your lordship that when he has enjoyed this thing,
I
and-
already said that.
and it is,
Therefore, we are saying you are ad item that he is getting city at compensatory allowance. We are not saying he is not disputing. He is saying this is not relevant. I have not suppressed. He is not saying I did not get.
when agglomeration area has been added,
We don't know how that is important. Anyway, if that is all, yes.
Lordship kindly comes to page 150, the finding. 158. The second paragraph. The findings have been made very categorical and very clear by the Honorable Single Judge. Lordship kindly sees it. May I just place it once, my lord? The contentions on behalf of the insurance company, however, cannot be accepted. Inspectors operating. If your lordship kindly recalls at page 40, the criteria, there also it says.
Just now we drew attention of the learned advocate to this
Yes.
paragraph. We have gone through it. We are saying that is precisely what we were observing.
I'm so grateful to you.
There is no distinction. Yes, take down. Heard the learned
wherein I have prayed for the consecution of financial benefits which are due and payable to me. May that be also paid to me, Your Lordship, in paragraph 34 of the said application.
Why should when we are not interfering with the judgment? That is already there in the judgment. Where's the question of passing the same order again?
The clarification has already
Read
been.
the last paragraph of the judgment under appeal. Read it, sir.
We have already paid. In the meantime,
That's not an issue here. Let's just read it,
Fine.
please.
Let the petitioner's seniority and ranking be effected properly and in accordance with law after taking into account the petitioner's eligibility to claim such a promotion.
Everything is there.
Even after retirement, my lord, my profit.
No, that's not an issue here.
Lordship, liberty.
You have not filed a cross appeal.
No, my lord, I'm not on that, my lord.
We are not going to say anything.
Only the liberty to raise those, my lord,
Raise what?
that it has not been paid, so that, my lord, let them pay those.
What were you doing till now?
And I have made an application. The application was kept pending.
All right.
Only for the reason that the
Just
appeal is
note
hard.
that we'll just note your submission. Yes, the learned advocate for the
regarding paragraph 35, 34, the claim has been made in the application. That we have already handed over to the honorable.
call the next. Sorry.
Item number 11.
We have already handed over.
So grateful to you.
Someone that has a zero. If you get a zero,
Pending applications, if any, stand disposed of. I always forget. I always forget.
100%.
None appears for the old case.
Item number 12.
Give the- Hmm.
Yes, sir. No problem. Yes, sir.
None appears for the state list in the
Item number 15.
Last together, my learned friends placed the case. I could not place the judgments. I was not having gyroscopy. Your lordship was pleased to direct me to place the judgment. Now I shall place the judgment.
Lordship, the impugned order starts from page 137. Paper.
ওড়ারটা কই ওড়ারটা আগের দিন
let us see 3621.
Yes, Lordship, that is 36.
That is the rule.
Lordship,
Yeah, yes.
My lord, come to page 139 of the paper.
Is there?
Paper my lord. 139. Oh, rule.
3621.
Is quoted. 139.
That is where judgment starts from page 137. No, he has.
No, where is the provision? We want to see just to refresh the provision.
Lordship, the
Yeah, yes, sir.
CISF. Excuse my mark.
I will.
Let us. Yes, sir. Yes, sir. Second show cause is not contemplated in the rule.
Of is not contemplated, that the quoted. It is not contemplated. Court did not take into Rule 36 sub 21 at all. In fact, he went on a different footing that the presenting officer cannot, then is what is the spokesperson of the disciplinary authority, so whatever he has said. But that is not, he has not considered Rule 36 at all. And there was no question of it is not contemplated. Second show cause notice is also not contemplated. He was sent the inquiries officer's report along with the dissent note of the disciplinary authority was sent to the charge official. The writ petitioner had received that, he has given his representation. If your lordship comes to the final order, paragraph 9, he has given his representation. So there was no question if there was absence of any opportunity of hearing. At each stage, lordship, that has been complied.
36, 21.
36, 21.
You are relying upon 36, 21, 2.
21, 2.
And why not 3?
Lordship, 3 has also been complied with.
Let us see.
Yes, yes, Lordship. Disciplinary authority shall forward a cause to be forwarded a copy of the report of the inquiry, if any, held by the disciplinary authority or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority together with reasons for
yes,
that has been committed.
Reasons for
Disagreement, if any,
yes,
and record its own findings on any article of charge to the enrolled member of the force who shall be required to submit.
If he so desires, so there is an opportunity contemplated.
Yes.
There is an opportunity.
Complied. He has given his representation to that. So, Lordship, kindly come to, I'll just.
That procedure has been complied.
Yes.
My lord, what I shall, on the last occasion, I shall praise the judgment. I will not have. For Supreme Court says, my lord, one person has been declared as not guilty. He is being declared as guilty. Supreme Court says, my lord, before that, a tentative findings has to prepare and an opportunity of hearing has to be given. Opportunity of hearing is a must.
Hearing, Mr. Judgment, that is inherent in this 26.
But Supreme Court
36, 21, 3 is precisely the same thing.
No, there is no procedure for opportunity of hearing. Supreme Court.
Please read 3.
I've read, my lord. 3.
Yes.
123, page 1.
There is no procedure of opportunity of hearing. I've seen.
Please, sir, please.
The disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any, held by the disciplinary authority, or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority together with reasons for disagreement, if any, and record its own finding on each article of charge to the enrolled member of the force who shall be required to submit, if so desires, the written representation.
Yes.
That is not. But what I am bringing, what I am, my lord, that before he has to give the charge sheet employee an opportunity of hearing. That is our Supreme Court number of judgments. I will place that I wanted to place. On the last occasion, your lordship was pleased to give me time to xerox and give that.
Hearing is also required.
Hearing required, my lord, must. That is the fairness, all fairness. On the last.
You mean to say personal hearing?
Personal hearing, my lord. So that he can
come. You challenge the CISF rule?
No. I don't challenge that.
You have participated under the provision?
I participated under the provisions.
And that's a statutory rule framed under the CISF Act.
Actor rule. But the Supreme Court says, my lord, if that is, even if not in the rule, that has to be read as if in the rule. Opportunity of hearing has to be given.
All right, let's see the judgment.
My lord. May I place the judgment, my lord?
Yes.
My lord.
So issue is only whether personal hearing was required.
Personal hearing before.
That is
Tentative hearing.
Because
No, next one.
You want to see it?
I'll do it.
You want to see it?
No, I'll just, if it's hearing needs to go.
No, he's probably relying.
Well,
Which judgment, sir?
This is my Punjab National Bank Adas versus Kunj hearing. My lord. Para 17, 18, 19. 17, 18, 19. That is page 96, 97. Page 96, 97. Para 17, 18, 19. Yes, what? 19. Most important. Paragraph 19 most important.
Yes, that is the most. Read it with 19.
Fine.
Read it with 19. This hearing has been used in 17 only.
19 also. Madam. The result of the aforesaid discussion would be that the principle of natural justice have to read into the regulations. As a result thereof, whenever the disciplinary authority disagrees with the inquiring authority on agriculture, then before it records its own finding on such charge, it must record its tentative reasons for such disagreement and give to the delinquent and opportune officer an opportunity to represent before it
Opportunity to
records finding.
represent. That's what we are saying.
My lord.
Hearing is not there. Hearing is in 17.
My lord.
Now, after that, the apex court in 18 and 19 says, relying on Karunakar judgment,
My lord.
that in either case, even if he accepts, even if he disagrees, at least an opportunity to represent should be given. And that is the requirement which in paragraph 19 it says has to be read in every rule.
My
No
lord.
personal, it does not contemplate a personal hearing at that stage.
But then
15.
Now it's a place, paragraph 18, 28 of 1999, 7 SCC 739, Joginath Bhagre. Paragraph 28. 28.
98. Citation.
1999, 7 SCC 739. Paragraph 20 starts from page 757. 757 bottom. May I please, madam? In view of the provisions contained in the statutory rule extra 28. 28, it starts from page 757. In view of the provisions contained in the statutory rule extracted above, it is open to the disciplinary authority either to agree with the findings recorded by the inquiring authority or disagree with those findings. If he does not agree with the findings of the inquiring authority, it may record its own findings, where the inquiring authority has found the delinquent officer guilty of the charges framed against him and the disciplinary authority agrees with those findings, there would arise no difficulty. So also, if the inquiring authority has heard the charges proved, but the disciplinary authority disagrees and records finding the charges are not established, there will also arise no difficulty. Difficulties have arisen in all those cases in which the inquiring authority has recorded a positive findings that the charges were not established and the delinquent officer was recommended to be exonerated. But the disciplinary authority disagrees with those findings and recorded its own findings that the charges are established and the delinquent officer was liable to be punished. This difficulty relates to the question of giving an opportunity of hearing to the delinquent officer at that stage. Such an opportunity may either be provided specifically by the rule made under Article 309 of the Constitution, or the disciplinary authority may, of its own, provide such an opportunity. Where the rule in this regard are silent, and the disciplinary authority also does not give an opportunity of hearing to the delinquent officer and records findings different to those of inquiring authority that the charges are established, an opportunity of hearing may have to be read into the rule by which the procedure for dealing with the inquiring authority report is proved principally, because it would be contrary to the principle of material justice of a delinquent officer who has already been held to be not guilty by the inquiring authority is found guilty without being afforded an opportunity of hearing on the basis of the same evidence and material on which findings are not guilty as well.
This is relying upon this is also relying upon Kunji Bihari Mishra.
Here is specifically stated opportunity of personal hearing has to be given. Zero 69 SCC 440.
You have seen para 34 of this judgment. Yes, any other judgment?
Well, now 20069 440. Para 10, 11, 12. Ten, 11, 12. 10.
They are all reiterating Kunj Bihari Mishra. That is the lead judgment.
Yeah, but may I place my 10, 11, 12.
It is only after hearing the appellant. You are stressing on only, it is only after hearing the appellant.
My lord.
In
Hearing, opportunity hearing has to be given. The conclusion of the High Court was contrary to the consistent view taken by this court. In that case, the disciplinary authority differs with the view taken by the inquiry officer. He is bound to give a notice setting out the tentative conclusion of the appellant. It is only after hearing, it is after hearing the appellant, disciplinary authority would arrive at a final point of view. There, the employee would again have to be served with a notice relating to the punishment proposed. In Punjab National Bank से कुंज बिहारी मिश्रा का काम है. Punjab National Bank is considered. The result of the aforesaid discussion would be principle of natural justice have to be read in regulation. As a result, therefore, whenever the disciplinary authority disagrees with the inquiry authority or any article charge, then before he records his own finding, such as he must record the entire basis of such agreement, give to officer an opportunity to present the report of the inquiry officer content its finding will have to be conveyed to the inquiry officer, will have an opportunity to persuade the disciplinary authority to accept the favorable officer. The principle of natural justice, as we have already observed, require the authority which has taken a final decision and can impose a penalty to give an opportunity to the charge officer to represent before the internal authority, records its finding or charge claim against the officer. But the requirement, para 12, the requirement of hearing in consonance with the principle of natural justice in that stage has to be into Rule 9(2) and it has to be heard. The final disagree finding would give an opportunity of hearing. It would give an opportunity of hearing to the dealing officer so that he may have opportunity to indicate the finding regarding inquiry officer, so don't suffer from an error. And that there is no occasion to take a different view. The simple authority at the same time has to communicate the delinquent officer the tentative reasons for disagreeing with the final inquiry authority, so the delinquent officer may further indicate there no reason on the basis of which disciplinary authority proposes to disagree with the findings recorded by the inquiry authority are not judgment that the findings of not guilty or recorded by the inquiry authority was not liable to interfere.
Yes.
Well, our division benches several.
So inquiry report was submitted. Disciplinary authority communicated a tentative disagreement.
Not here, not communicated. Here only he disagreed, not anyway, finally disagreed, asked to submit representation, then gave the punishment.
Let us see. Let us see the notice given by the disciplinary authority.
My lord. Page 104 of the report.
104.
SK Sarkar Deputy Commander CISI MCL. Page 104.
Hmm. Yes.
My lord, my lord, another division bench, my lord, has been pleased to examine the rule CICF rule also with these judgments. You are also previous again, my lord.
Rule 36.
Rule 36 has, with these judgments I place before my lord, Rule 36 has also been examined. There are 5 and 6.
Huh?
And where is the final order passed?
My lord, must.
That is at page 121.
100 and
21, 20th December. Paragraph 9 deals with his representation. That is at page 123, Lordship, paragraph 9. Paragraph 8 and paragraph 9, Lordship.
And where is the finding regarding statement given by PW1 in the disciplinary authorities order? Regarding Jamshed Alam, he has given the finding in paragraph 10.
Paragraph 10.
And regarding the other person?
Lordship, paragraph 10 is also the representation.
Huh?
Paragraph 10 is also the representation.
No, paragraph 10 is
I have carefully gone through the representation submitted by.
correct. So in this, he has given the finding why he has relied upon statement of Jamshed Alam.
Yes. Sir.
Now he has relied on another statement of PW1.
Yes.
So where is the finding regarding PW1? Executive S. Mukherjee. Inspector Executive S. Mukherjee.
Lordship, it comes further down. It says, times down, Lordship, Inspector Executive S.K. Mishra has also corroborated the statement of S. Mukherjee. The inquiry officer submitted. Inspector S. Mukherjee PW1 has also clearly disposed in his statement that the charged official was suspiciously talking with criminals at about 0015 hours. Lordship, in that same paragraph. Just
Oh, just yes, Inspector.
After Jamshed Alam. So that has also been dealt with.
Is entitled to opportunity to make presentations. That opportunity is to be given prior to
Madam, come to page 125.
Yes,
In between, my lord, there is some mark.
yes.
Before that, MD Jamshed Alam, before that, Jamshed Alam was apprehended by SCGD OP Thapa, but he was not present where during the course of apprehension, the CPW4 was OP Thapa who apprehended the criminal. Mr. Jamshed Alam reported that in his statement that he was PTL duty along Constable Satbir Singh. Advice he had a message.
Just one question. PW1, did he appear before the inquiry officer? PW1 is an Inspector Executive S. Mukherjee. Did he appear before the inquiry officer? Where is the inquiry report? Because Jamshed Alam has not appeared.
He has not appeared.
So therefore, we want to know whether S. Mukherjee has appeared. These are the only two persons which the disciplinary authority says he has not considered and therefore he has not accepted the fact. Though Jamshed Alam did not appear Disciplinary authority said his statement is there from the preliminary inquiry.
Lordship, from the gist of statements at page 107.
107.
Yes, well, Lordship will find Inspector S. Mukherjee, PW1 statement.
PW1, yes.
Bharat region video version.
Cross-examined by the
So before the inquiry officer, whatever he is stated is at page 108 at the top of the page. Prior to that is also a statement given in the preliminary inquiry. Statement here. Even if we had, it would not be a before country. It could not sustain because his statement does not. Therefore, his written statement cannot be. He has come for it.
Supply finding.
Yes.
Only I argued, my lord, before the learned Singh also, the one opportunity of hearing by disciplinary authority.
Correct.
And would have clear all the doubts.
That is the only conclusion of the single judge also.
Fine.
He has proceeded on the consideration that the opportunity was given post-decisional.
Fine.
It's a post-decisional hearing and therefore it will not subserve the principles of natural justice. That is the substance of the finding by the single judge. It's not whether he was given personal hearing or not. That is not the issue. Personal oral hearing is not required. You will get judgments of the apex court that wherever expression hearing is used, it does not always mean oral hearing. It indicates an opportunity in compliance with natural justice. This is a judgment also.
But this judgment, my lord, let's clear, right? 28. The opportunity of personal hearing.
Which one?
My lord.
No. That has been considered by apex court in Gunj Bihari Mishra.
Gunj Bihari Mishra earlier, my lord.
No. Gunj Bihari Mishra is
99.
Huh?
399.
Yes, Gunj Bihari Mishra is later. That was considered by Gunj Bihari in the Gunj Bihari Mishra judgment. After that, the apex court in paragraph 18 and 19 of Gunj Bihari Mishra has said represent. No hearing is contemplated. And everywhere where there is a requirement of hearing, it does not necessarily mean an oral hearing. It refers to an opportunity.
It's a trial that he has to be present, participate during the
Before the inquiry officer.
Because after all, once a charge is leveled against it, it contemplates civil contempt.
96(4) SCC bolo to nikal. 96(4) SCC.
At that point of time,
Page 69.
He is physically present. He is examining cross-examining the witnesses. He can produce witnesses. So that is all in
But he
context.
has raised the issue, therefore we want to answer that issue also. You have any judgment, hearing does not always mean oral hearing.
Then we'll have to, because he had.
This is not raised before the single judge.
No,
This he is raising here for the first time.
subject to correction. I think the Calcutta decision was, I mean, they had prayed for personal hearing. Was it something like that? Because here he has not. He has given the.
No, personal and oral hearing are two different things. The
That
person,
been construed,
huh?
But here there has been no prayer as such. He has given his representation.
He is saying that hearing means oral hearing. So therefore there are judgments. So let's just come with one or two judgments.
My lord, Calcutta Law Journal case, I have last remember. There are 12, 11 and 12. It's clear that by coordinate range. There are 11 and 12.
Right. To correct it, I'm not sure. There for personal.
Personal hearing, not oral hearing. Personal hearing means by way of a representation.
Personal hearing means so that he can personally apprise the authorities what happened. That is not possible by writing. That has to be always done by personally appearing before him.
No, that we have understood. Your insistence is that we should read into the CISF rule that in case of disagreement, not only the disagreement note has to precede a conclusive finding of guilt, but at this stage, after the disagreement note is communicated, you must be allowed an opportunity to personally appear. Then why not personally appear at the appeal also? Why not? See, when statutory authorities are saddled with the responsibility of compliance with natural justice, it does not at every stage contemplate an oral hearing. An oral hearing is distinct from a personal hearing. Personal hearing can be sufficiently allowed by giving an opportunity to represent and requiring a consideration of the representation by a reasoned order. Oral hearing, whether at every stage, then why not? Then you should get an oral hearing even at the appeal.
There also is a called a Ram Sutta, I am brought my lord, called Ram Sutta. Oral hearing, personal hearing has to be given in appeal.
No, therefore personal and oral, personal, you are using the terms interchangeably. We are not on personal. Personal hearing is allowed, but oral hearing means to appear there physically and make your submissions. We will see. Any judgment you have.
Otherwise, giving representation is meaningless. Will not serve the purpose.
No, then the entire law founded on the Kunj Bihari Mishra will have to be reconsidered. Kunj Bihari Mishra clearly says opportunity to represent. That judgment, I don't know, or we don't know how you can get over that judgment. The judgment that you are trying to rely on is already considered by Kunj Bihari Mishra, and Kunj Bihari Mishra is 3 judges, if we are not mistaken. 3 judges.
Yes, Lordship.
It's a 3 judges. So therefore, that will prevail. Paragraph 17. In fact, it is all the more clear because in 17 it uses the expression hearing, and in paragraph 18, 19 it says represent. So therefore, wherever statutory authority is obliged to give a hearing, it does not mean oral hearing. क्या हुआ नहीं मिला वो judgment? 96 बोले उसको नहीं दिया 96 for SCC 96 for SCC page 69.
Another thing, my lord, all the judgment says there must be some tentative findings by the disciplinary authority.
That we have already said.
That has not been done yet.
That we have seen.
He
He says beyond doubt. I find you guilty beyond any doubt in the penultimate paragraph. And then in the final paragraph, he says, say what you have to say. That we understood. But you are taking it one notch higher by saying that after this, I must be orally heard. We are on that.
My prayer is to, my lord, opportunity of hearing, my lord, oral hearing. And second is, my lord, the tentative disagreement, no?
The 4 SCC. For further consideration. 96 4 SCC, page 69.
96 for page 69.
Jesus Sales Corporation, yes. Oh, so it will come on Thursday, sorry.
Yes.
You see paragraph 4. See other judgments.
Number 20. This matter, my item is item number 14. But at 2 p.m., my matter could not be taken up as because the learned government leader was appearing and he is to take instruction. So situation is such, my lord, I'm not pressing it.
Call it, call it.
Mine is 14, not 13 is Mr. I have
Yes.
matter 3 p.m. matter fixed at court number 5, my lord.
Right now, your matter is fixed at 2 p.m.
Item number 14 before your lordship, my lord.
Fixed at 2 p.m.
Yes, my lord.
Yes.
That matter, my lord, as the learned government leader is appearing for this.
We have understood. Just let us,
I-
just give us 2 minutes. We know you are in a rush. Still give us 2 minutes.
Item 14. No. Another 2 p.m. matters, my lord. 13 is of Mr. Shen.
Yours is after his.
Yes, my lord. 14. My lord, courtroom number 5, one matter is fixed at 3 o'clock. That is the.
That case will record an order anyway. 14, hey. Call 14. Just please wait.
14. My matter relates to resignation. He has to take instruction.
Keep the file. When the matter was last taken up on
Matter relating to specific.
we are going through the order. Just
Come back to your lordship.
Hmm. Yes. You are giving us some decision.
Yes. Shall we not? If I just briefly summarize the issues which I had said, Milord.
You have seen our last order.
Yes, I've
So all the issues we have recorded.
one thing, Milord, trial court judgment regarding it also said that the agreement was unregistered. The stamp act unregistered. So there I had submitted, Milord, that judgment I will give. Section 49 of the Registration Act itself carves out an exception.
Oh, yes, yes.
That even if the agreement is unregistered, same is not a bar to be taken into consideration in a suit for specific purpose. That the statute itself says. So that is also one of the findings which I am challenging. And regarding the readiness and willingness, that one judgment I had cited, which your lordship has recorded, one more judgment on readiness and willingness I shall give, and then I'll come to order 4127 point. Kindly take the Registration Act once, section 49 of the Registration Act. Just if I place it, your lordship, it will come back to your lordship.
Yes, you had placed it that day.
Yes, then I'll go to the judgment of the 2310 SCC. 725. Kindly see paragraph 2 1. Paragraph 2 gives the facts. May I please? Facts leading to the present appeal in a nutshell are as under: respondent is the original plaintiff, institute civil suit number such and such for specific performance. The agreement to sell after the chief examination of plaintiff one of the application filed by the appellant original defendant. Preliminary issue was framed by the trial court on the admissibility of the agreement dated 10 September 2013 evidence. It was the case on behalf of the defendant in view of Tamil Nadu Amendment Act to the Registration Act under which the instruments of agreement relating to sale of immovable property of the value of 100 and compulsory required to be registered. The unregistered document shall be inadmissible in evidence. On the other hand, relying on 49A and C, it is submitted an unregistered agreement to sell can be admitted as evidence of a contract for specific purpose. The trial court held the preliminary issue in favor of defendant against the plaintiff by observing that unregistered agreement dated circumstance shall not be admissible in evidence.
Paragraph 23 is the answer.
I am not troubling your lordship. Now let me come straight away on the aspect of readiness willingness. One judgment I had cited, one more I just show your lordship. 22 volume 14 SCC 793. You will kindly come to paragraph 21. one, your lordship has got.
Yes.
Readiness and willingness are not one, but two separate elements. Readiness means the capacity of the plaintiff to perform the contract, which would include the financial position to pay the purchaser. Willingness refers to the intention of the plaintiff as a purchaser to perform as part of the contract. Willingness is inferred by scrutinizing the conduct of the plaintiff purchaser, including attending circumstances. Continuous readiness and willingness on the part of the plaintiff purchaser from the date the balance sale consideration was payable in terms of the agreement to sell till the decision of the suit is a condition precedent for the grant of relief of specific performance. Expression readiness and willingness used in section 16C has been interpreted in a catena of decisions by this court in the light and fact of the facts and circumstances under consideration for the purpose of granting or refusing to grant the relief of specific performance of a contract. The said expression cannot be interpreted in a straitjacket formula. In a very apt decision of this court, in such and such a three-judge bench of this court, construing a plea of readiness and willingness to perform in view of the requirement of 9 section 16C and its explanation observed as under. So the whole gamut of the issue raised is how to construe a plea specifically with reference to 16C and what are the obligations which the plaintiff has to comply with in reference to his plea and whether the plea of the plaintiff could not be construed to conform to the requirement of the aforesaid section, or does this section require specific words to be pleaded that he has performed or he has always been ready and willing to perform as part of the contract. In construing a plea in any pleading, courts must keep in mind that a plea is not an expression of art and science, but an expression through words to place fact and law on scale for a reading. Such an expression may be pointed, precise, sometimes vague, but still it could be gathered what he wants to convey through only by reading the whole pleading, depending on the person drafting it. In India, most of the pleas are drafted by counsel, and the aforesaid difference of pleas inevitably differ from one to the other. Thus, to gather true spirit behind the plea should be read as a whole. This does not distract one from performing his obligations as required under the statute, but the test whether he has performed his obligations, one has to see the fit and substance of a plea. When a statute requires any fact to be pleaded, then that has been pleaded maybe in any form. The same plea may be stated by different persons through different words, then how could it be constituted or word? Unless the statute specifically requires a plea to be in a particular form, it can be in any form. Specific phraseology or language is required to be taken, required to take such a plea. Language in 16C does not require any specific phraseology, but only that the plaintiff must aver that he has performed or has always been and is willing to perform as part of the contract. So the compliance of readiness and willingness has to be spirit and substance, not in letter and form. So to insist for a mechanical production of the exact word of it is to insist for the form rather than essence. So the absence of form cannot dissolve an essence is already pleaded. It was observed that it is significant that the explanation carves out a contract which involves payment of money as a separate class from section 16C. Explanation 1 uses the word, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. This speaks in a negative term what is not essential for the plaintiff to do. This is more in support of the plaintiff that he not tender to the defendant or deposit in court any money, but the plaintiff must, as per explanation 2, at least aver his performance or readiness and willingness to perform as part of the contract. In Sukhbir Singh, this court has laid down that law is in no doubt that it is not a condition that the respondent should have ready cash with them. It is sufficient for the respondent to establish that they have the capacity to pay the sale consideration. It is not necessary that they should always carry the money with them from the date of the suit till the date of the decree. So this is, my lord, the test. Now, my lord, I would, before I go on to the other aspects, I would try to show on what basis the learned court below has found that requirement of readiness and willingness was not fulfilled in the facts of this case. Now, just kindly come to, my lord, the operative part of the judgment of the court below once. as I had placed on the last occasion, my lord, the operative part starts from 138.
Yes, we have gone through this.
Just to apply this judgment to the fact. I am not going to place the entire. Why I say that, my lord, the greatest of respect, the learned court below went in error in finding that there was no readiness and willingness. That part only. Can we see the first line? From the entire pleading, it is nowhere possible to find out that plaintiff had ever offered the balance amount of 10 lakh out of 35 lakh as per agreement. This, my lord, in my most respectful submission, is the first part which is not required. I need not show my deposit or tender. It has to be read as a whole from the entire circumstance. On the date of the agreement, 25 lakh was paid already. And then what is my case in the plaint? My case in the plaint is not simpliciter that he was to, I have to just deposit the balance and have it executed. No, my case is something else. It's a performance of reciprocal obligation which he failed, he repudiated by breach. That is why specific performance. This is a difference from any other case of specific performance. Usually what happens, my lord? It is like this, my lord. I have paid, suppose, an initial amount. Then I am supposed to pay the additional amount, balance amount, have it executed. My usually plaintiff's case is I am ready and willing to pay the balance amount, but he is not executing the deed. This is like a case of where I have to show my readiness and willingness. Defendant is not required to do anything. This case is different. This case, my specific plaint case is that agreement done, initial 75% paid. I was not required to pay 75%. I paid 75%. Thereafter, until and unless defendant does ABC obligation, I cannot go ahead. Then I say that when I asked him to do that ABC obligation, at least one letter is exhibited with specific, and he replies to that by saying that he need not perform, and he went on disputing the agreement. So that is amounting to a breach and repudiation. So therefore, here the readiness, the proof
He
of
responded by saying that you are relying upon some unreliable document.
exactly. So that shows his intention not to perform his reciprocal obligation and repudiate the contract. So here the test of my readiness and willingness will be slightly different from an usual specific performance case. Therefore, this consideration which the learned trial court records here, that is not a relevant consideration at all.
Where is the prayer in the suit?
For specific performance, kindly see the plain prayer, page 14. First prayer. He will have to perform his part. Whatever is there is in the agreement. Next, my lord, if your lordship comes back to 138, then I am not placing thereafter. The learned judge has quoted the
every suit for specific performance, the agreement sought to be enforced is not an issue.
Is not an issue. Cannot be an issue.
In every case, it is not.
Yes. Cannot be an issue.
Here, when he says that it is not reliable, the terms and conditions which you want to enforce, or you want to compel him to perform, when he disputes the very existence of such a condition and the document based on which you make such a plea or allegation, whatever you may call it,
then obligation, suppose he raises that stand in the written statement regarding, then an issue is framed, is the agreement valid and binding.
So this agreement, this issue, was it considered?
Yes. And the agreement was marked as an exhibit
No.
without an objection.
So therefore,
So, my lord, who has to prove if he is saying, I have proved the agreement, signature, everything?
who tendered the agreement?
My second witness. So there, well, kindly see.
It was proved. How it was proved? By tendering the document. Witness was there. Which witness proved the document?
PW2.
Please show.
Yes. Last time I showed. I'll just show. From this is the second paper book. Kindly come to 103.
First paper book.
Yes.
Only exhibit no declared capital given to constitutional later on. I have signed it. Drafted it and signed it.
That is it. I cannot recollect about the payment. But it was presented to me for preparation. Also, there was investigation of title. There was not.
The Lordship has seen page 100
Cross-examination.
104.
103 at 104.
Yes, we are looking at that. This is the advocate who prepared the agreement.
Yes. Yes.
Beyond preparation, he does not say anything.
Yes, he has said, I drafted it and signed it to that effect. He has explained the deed is for the sale agreement.
That's right. So preparation, he vouches for the preparation.
So now, my lord, the burden.
He does not in any way say anything about subsequently being signed by the parties or any action taken pursuant to the preparation of the document. And on that basis, it has been admitted as an exhibit.
Yes. Now the question
So it was prepared.
Question is, my lord, it has been disputed if plea is raised in the written statement.
Unless you.
If a plea is raised in the written statement, and that plea, the burden of proof is on the person who is raising that plea.
That you have argued.
So therefore, my lord, I have no further obligation to discharge. I have exhibited the document.
You have exhibited a document which supported it by a PW2 who supports only preparation of the document and nothing beyond that. That I prepared and I signed it. I don't know anything. I cannot recollect anything beyond that.
I cannot recollect. Later on, it was paid in my presence, is on the deed. He said about the endorsement.
Later, one endorsement that it was paid in my presence is on the deed.
Yes.
Yes, the amount is not possible to recollect. Yes, the mother deeds were presented to me for preparation of this deed. Yes, also caused investigation of title. So this lawyer probably he undertook a search regarding the title and then he prepared the document and he says, yes, there was an endorsement.
If your lordship now kindly considers the question of burden of proof. I have come up with a case that there is an agreement agreement has been partly performed. Balance
No,
obligation.
we are on something, we are trying to understand something different at the moment. Whatever you say you have proved, can the court take into consideration in anything in excess of that?
No, I'm saying, my lord,
Or anything as a natural corollary or a consequence of that?
May I ask this question to myself, my lord? If a document is marked as exhibit and there is no objection raised,
That you have said, yes. That you have said.
then what is the effect of that document?
All right.
The agreement, it is not the case that if it had been an ex parte suit, consideration may be different.
We'll see what they have to say. We have
I have
understood.
come to that. But what I am on, against this plaint case, there is a case in a written statement. Written statement, suppose a defendant alleges that this agreement is not executed by the defendant. Then
who says that it was executed by him? Who said that it was executed by him? That's what we are trying to ascertain. Who has said before the court regarding the agreement being executed by him? A preparation and endorsement of payment. Who says that it was executed? In whose presence? Who has supported the execution of the agreement?
it is not a case of support.
So therefore, please, when you say that once I have discharged my obligation, it is for him. You never discharge your obligation as per the material till now that it was executed by him. There is a preparation, there is an endorsement which is supported by PW2. We don't know, we have not seen the other records. But regarding execution by him, who has supported? That's what we are asking.
This is something which has
to that you said that once it is admitted, the document has to be considered as a whole.
Yes.
That we have understood.
Now, against that, if the document has to be discarded, it has to be discarded on the basis of some proof which is coming from the adverse side.
Therefore, we are saying the proof, the onus will shift only insofar as the evidence is brought on record by the plaintiff, not for something which the plaintiff has never proved.
No, I am not.
For that, an onus cannot be cast to prove the negative.
Suppose it is like this case.
You would, if he would have said that yes, it was also executed in my presence, then he would be required to say that how he is saying this is not his signature. He never said regarding execution. That is precisely what we are asking you. We don't know about the other PWs, but he never said. He says prepared an endorsement regarding an amount. Beyond that, I cannot recollect anything.
I'll show the other evidence also.
We are only observing so that if there is something you don't miss, therefore we are saying. You may proceed further. Let him look for it.
I'll just come to that.
Now let us proceed with the further.
But my argument in continuation of this will be the allegation that there was no agreement or there was no existence of any agreement. That allegation, that burden was not proved by them.
To prove the negative?
No, their written statement case.
They will prove that there is there is something is absent. How they will prove that something is absent?
Because they have made out a case. Because
they have said what you are saying is not acceptable. They have not made out a case. They say it is not reliable because it is. Yes. He said it was never signed by us. It is a forged document. He has gone to the extent of saying that you have created ruckus at the office. Criminal case was lost. All these allegations here.
This fraud and forgery.
But the other things are not relevant. If the agreement had been supported by any evidence, we don't know. Then what you are saying, maybe we will have to consider. But if nobody has proved the execution of the agreement merely because a document is marked as an exhibit, can the court take anything beyond what is there on record as a natural corollary or a consequence, a natural consequence?
Kindly see, my lord, Kindly come to
They're only by marking the document as exhibit. The whole contents will go. Definitely not.
Yes,
kindly come to my lord, the further examination in chief of PW1.
page please.
This is in the
Give us the page please.
page number 20.
Who is he?
He is the plaintiff.
He is the plaintiff himself.
Kindly see the on
That we have marked already. You showed it on the last day. The last line at page 20. Defendants agreed to sell the remaining portion of the property, also executed a deed of agreement on 25/8/93, and the consideration of the remaining portion of the building was fixed so and so. 3 copies of agreement were prepared. It was settled that 1 copy would be kept and I had but the defendant did not clear up the municipal tax of the suit building. They also did not obtain any clearance from the competent authority. This you had placed.
this. There is no cross examination on this. Then if you now regarding the agreement that it is an admitted document, that I will also show from certain letters which have been exchanged between the parties. Where
Those letters were exhibits.
ওটা কি exhibit হয়েছিল? Just one second.
Exhibit numbers.
No, that I will have to rely upon my Order 41 Rule 27 to show that these documents.
Therefore, we framed the question on the last day.
So I'll straight away come to Order 41 Rule 27. But what I want to say is, this evidence of PW1 read with the marking of the document through PW2 is unquestioned. And thereafter, they have not proved their own case in the written statement regarding that agreement. That they did not, this is not my signature. This amount was paid to me. The payment of the amount is an admitted position. It was for a different.
Admitted.
Yes.
Payment is admitted.
It is by
where is the admission? Let us see.
It is by check.
No, where is the admission? Admission cannot be unilateral. Admission has to be a bilateral thing.
But that is from the judgment itself.
Yes, so let us see.
Kindly see from the entire pleadings.
Page, please.
Page 138. They have said it is nowhere possible to find out the plaintiff had ever offered the balance amount of 10 lakh out of 35 lakhs. The judgment proceeds on the premise that 25 lakhs was paid.
No, that is the court's observation. You said there is an admission.
I am saying on the basis of the admitted case, this finding has been arrived at.
So where is that admission forming the basis of such a finding?
That you got to get in written statement itself.
Yes, let's see.
But there is one place where he says here, they have said in paragraph 20 about 25 lakh, but said it is in cash. That man like the plaintiff should have disclosed his source of amount of 25 lakh in cash, and that must be noted in his income tax return. This sort of a averment is here.
Money in cash.
Yes.
He is not saying that it was paid in cash.
He is saying that it could not have been paid in cash.
Correct. So therefore he is doubting the modus of payment itself. That is not possible. How can he show 25 lakhs in cash?
But the finding proceeds on the premise that 25 lakhs was paid, only the balance of 10 lakhs was remaining. For that, I could not show my readiness willingness. This is the finding of the court below.
No, what the court says does not say that the pleading show payment of 25. The court says the pleading does not show that he ever offered the 10 lakhs. It does not.
Offered the balance amount of 10
No pleading shows that yes, we understand what you're trying to say, but this cannot be a finding that 25 was paid. From the entire pleading, it is nowhere possible to find out that the plaintiff had ever offered the balance amount of 10 lakh out of 1,000 as per agreement dated so and so. So therefore, this does not mean that there is a finding regarding existence of any of these three facts, because the agreement is also mentioned here.
Yes.
But the court goes to a finding that it is not, there is no agreement. So therefore,
that is the point which I am taking. That how can the court go into the question of and dispute as to existence of an agreement when the specific disputes which were raised by the defendant were not proved?
That you have said, yes.
Kindly come thereafter. Kindly see, they have quoted the written agreement, written notes of argument. I am not placing. Now your lordship will kindly see 140.
No, all that you have placed. Please don't. There is no whisper as regards the date of.
I'm not placing this.
Everything
Now,
you have placed.
Lastly, where we come down to the last sentence of page 140.
Yes, that also you have placed belong to the company and not been attempted to prove the letter dated so and so address.
Then kindly see, by this letter, ANSEN was asked to execute and register a sale deed in respect of property inherited from the deceased. By the letter, readiness and willingness to pay rest amount has closed, which is contrary to the record.
All right.
That is my argument. In another letter addressed to Certificate 20 within relief for on payment of 10 lakhs, but the readiness has never been shown or communicated to the defendant. I have come to court immediately after this letter. This is the last in the series of letters. This reply to this letter resulted in my cause of action to come to court. So there is no question of showing my readiness, willingness thereafter. This is the point.
So all your arguments are on the premise that the agreement is admitted. All your agreements are on the premise that agreement is admitted. Once it is admitted as exhibit without objection, the agreement is admitted, and therefore everything follows.
No, my only other point is if there is any dispute raised by the other side, with regard to the agreement, after it has been marked as an exhibit, that addition.
Correct. So everything is founded on admission of the document as an exhibit. Once it is admitted as an exhibit, then it is already proved. That is what you are saying. The document as a whole is proved.
But with one rider.
Now, if they want to dispute anything, they have to come out with material.
If they want to make a positive case that this agreement is vitiated, then that burden of proof is on them.
Obviously, but that can only be after the evidence, after the agreement is proved or admitted. Prior to that, how can it be?
But the court below is also not saying that the agreement is not proved.
No, but we are asking you.
Yes, but
You are before us, we are asking you.
yes.
We are entitled to see all this. So we are giving you an opportunity rather.
I rely on one of the evidence of PW1.
PW1 and 2.
PW1 and 2.
Let's proceed then. You
Now,
come back to the argument that you were advancing.
Now, my lord, with regard to the additional document, Order 41, Rule 27. My lord.
Yes.
Now, your lordship will take this judgment 2022 7 SCC.
You have not come with the recent judgment.
I could lay my hands on this 22.
No, it was largely circulated in the journal websites. Maybe last month. Live Law and all these places. I did go through it. I glanced through it. Taking the entire law into consideration. We thought you will come with that. That's why we had asked you on that. Perhaps last month. Very well, whatever you have come with, you proceed. There is no substantial shift.
Not substantial shift.
But it's better to refer to the latest rather than relying on 2-3 judgments. And that judgment is perhaps quite an elaborate judgment.
What is the important thing? But if your lordship sees the section once,
could you locate the judgment?
There is one 2025, my lord. Saying.
Iqbal Ahmed.
Who is the which honorable judge is the author?
Justice Narasimha.
Pardon?
Justice Narasimha and Justice Chandurkar.
Let us see this judgment.
Iqbal Ahmed.
Iqbal Ahmed.
Versus Abdul Shukur.
Yes, you want us to see the provision.
Yes, 27, 41, 27.
It is quoted in this judgment. No.
I'll just place, my lord, Order 47.
CPC. CPC. CPC in the court.
Yes, read it.
Yeah, just place. And I am relying on each clause is disjunctive. Kindly see B. 27(1) A, then B. First is A, then AA. Party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after exercise of due diligence, be produced by him at the time when the decree appealed against was passed. I have to prove this. But my submission, even if the appellate court feels that this document was with them but it was not produced, then B comes for it. Appellate court requires any document to be produced or any witness to be examined to pronounce or for any other substantial cause. So on that manner, this judgment proceeds, if your lordship sees. However, paragraph 6 of the judgment. This was a land acquisition case. However, the High Court, while considering the application for additional evidence, has not appreciated the fact that documents which were sought to be produced as additional evidence might have a bearing on the determination of fair market value of the acquired land. It is to be noted that except sale deed dated such and such, which was rejected by the court below, no further evidence was on record to determine the fair market value of the acquired land. It was a case of awarding of fair compensation to the landowner whose land has been acquired.
Some books are here, some books are there, some are there. Nothing is organized. You don't know where what is. How can you trace? Impossible. The way the book should be. You know where which book is. It's scattered all over the thing. Never find it. Paragraph 6.
Paragraph 6. However, the High Court, while considering an application for additional evidence, has not appreciated the fact that the documents which were sought to be produced as additional evidence might have a bearing on determination of the fair market value of the acquired land. It is to be noted that except the sale deed dated 29 December 1987, which was reviewed, no further evidence was on record to determine the fair market value of the acquired land. It was a case of awarding of fair compensation to the landowner whose land had been acquired for public purpose. It cannot be disputed that claimant whose land is acquired is to be entitled to the fair market value. It is true that general principle is that appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. But however, as an exception, Order 4127 enables the appellate court to take additional evidence in exceptional circumstances. It may also be true that the appellate court may permit additional evidence if the conditions laid down in the rule are found to exist and the parties are not entitled as of right to the admission of such evidence. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case, and the evidence has a direct and important bearing on the main issue in the suit, and the interest of justice clearly renders it imperative that it may be allowed to be permitted on record, such application may be allowed. Even one of the circumstances in which production of additional evidence under Order 4127 by the appellate court is to be considered is whether or not the appellate court requires the additional evidence so as to enable it to pronounce judgment or for any other substantial cause of like nature. As observed and held by this court in such and such, the admissibility of additional evidence does not depend upon the relevancy to the issue on hand or on the fact whether the applicant had an opportunity for adducing such evidence at an earlier stage or not, but it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. It is further observed that the true test therefore is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. So, my lord, here, my lord, I would like to submit that since the court below has gone on the aspect of readiness, willingness not being there, therefore, my humble submission will be that there are certain correspondence exchanged between the parties. And I say that this is admitted correspondence because those have been replied to. where your lordship's doubt regarding existence of the agreement will also be cleared. So if these documents are taken into scene, then the doubt which the appellate court is having regarding existence of the agreement, that will be cleared. The ground taken by the trial court to decline specific performance readiness and willingness, it will throw some light on that issue as well. So therefore, my lord, I will humbly submit that these 2-3 correspondence be kindly taken on.
All right.
So, my lord, if I may show 2-3 documents which I want to rely upon as part of the order 4127.
You have read paragraph 11 of this judgment, 11 and 12, which you are relying upon.
Yes, in this case, these documents, what I am saying, these have been in my letter replied to. This kind of a document. So there is no necessity to again relegate the parties to prove this document.
So they are not objecting.
They cannot. They have.
They are not. No, no. You can't say that they cannot.
I don't know whether they will object. They have. They have.
Have
not,
they filed any opposition to the can?
They have not filed any opposition.
Very well.
Lordship sees 2-3 letters, if I may be permitted. Thirty. No, এটাই দেখায়। That reply আছে page 46. We can say that. But if your lordship, sorry. Seven, eight, old letter.
Yes, yes. Which page? Which?
Kindly come to the second part of the paper book. No, the first paper book.
Oh, second part.
At page 37.
This is by
This is by our advocate. It is replying to S.K. Gupta, that is of their chartered accountant's letter of 30th of May 1994. This is a reply to
referring to page 36.
37 probably. Letter of Shomorendranath বিশ্বাস, advocate.
Yes.
Kindly see subject and reference. Your letter dated 30th of May 94 through S.K. Gupta, FCA. Replying to their letter. Under instruction of your client, such and such, you are committed to selling of the property under agreement, free from all encumbrance, claim, demands, whatsoever they agree. But although it is a long time span since the said agreement was entered, you have not squared up your account with Calcutta Municipal Corporation in respect of the amount of arrears of municipal dues and straightened up the records of Vishnupur Electric Supply Industrial Development Company Limited and the Office of Registrar of Joint Stock Company. It appears that you are not as much busy in respect of your part of the contract as it should have been, and your this passivity and tardiness on way to ascertainment of smooth marketability of the property, among other things, but for which my client is unable to indulge in preparation of proceeded draft or final. Property under agreement being made up to smooth market as agreed upon, he has stated my client obliged and shall to supply you copies of final sale deed as required for your steps with the income tax authorities and complete and conclude his purchase as stipulated in the agreement. I have instruction to request you to take all steps expeditious as possible for redemption of marketability of your said property and for a smooth and within time conclusion of sale under agreement, my client remaining ever ready with finances to perform his part and looking forward to the purported redemption of smooth marketability. Now kindly come to page 46, which is a reply by S.K. Gupta. Replying to the advocate, your reply dated 31st July 1994. Under instructions from him, I shall request you to contact your client who has already been informed by me about the present position of corporation tax. Regarding rest portion of the letter, I am unable to understand what you have wanted. My client is always agreeable to comply with requirements which you want from my client. So agreement is not disputed.
Which agreement?
Now kindly see page 37 at the top, subject. In the subject is mentioned in terms of sale agreement dated August 25, 1993 between my client and you and others. So this he is replying to this letter. He is referring to the obligation of property tax and etc. Then তারপরে এই চিঠিগুলো কোন চিঠিগুলো দেখাবো বলো? Also kindly see the letter at page 43. This is also their letter, S.K. Gupta's letter, addressed to my client.
You are a tenant in the premises.
Yes.
Yes.
Page 43. This is in reference to my letters, 1st July 94 and 30th of May 94. So, here also they are saying about the conveyance corporation tax liability on the basis of order passed by, it appears that there is no matter pending. So there is no dispute with regard to the transaction. ওটা তো আলাদা কথা, এখন হয়নি সেগুলো। Then, my lord, your lordship will kindly see also page 53. This is of course referred to in.
What was the period for performance of the contract?
1 year subject to performance of their obligation. That is clause 14 which I have placed.
What is the date of the contract? Agreement that you are relying upon?
Yes, 25th August 1993.
Yes.
Then your lordship will kindly see page 53. This is referred to in the plaint at paragraph 15. After this, or in the sequence of date, it is page 53 first, that is 28th February 1994. Then, my lord, then there is a Bengali letter at page 33 that is dated 25th of May 1994. It is also pleaded in paragraph 16 of the plaint. Yes, 33. This is in Bengali, but the date is 25th of May 94. This lordship can refer to para 16 of the plaint. Then, in the sequence of date, my lord, is the letter of the defendant, that is 30th of May 1994, which reference your lordship will get at page 43 of the paper book. S.K. Gupta, while writing the letter at page 43, himself refers to his earlier letters, 30th of May and 1st July. So this is the sequence, and from page 43, your lordship will see that the deliberation is with regard to corporation tax and etc. So therefore, it is talking about the transaction concerning that agreement. Then, my lord, there is another letter of 1st of July that is also referred to in page 43 of the defendant's chartered accountant. Then comes my letter at page 37, which is dated 31st of July. That I have just now placed. This is a reply to his 30th May letter. Then, my lord, 8th August 1994, which I have placed, page 43. Then exhibit document, 8th December 1994 and 23rd December 1994. So this is the sequence. So therefore, all throughout the parties have been discussing on this agreement. And first time when they dispute this agreement is 23rd of December 1994. There is the first whisper of no agreement. Prior to 23rd of December 1994, we were at least ad idem regarding an agreement. We were ad idem on the conditions of the agreement, clauses of the agreement. Because whatever I have said in the plaint that you are to perform this municipal tax, the income tax clearance, that deliberation and discussion your lordship is finding in their letters. Because if your lordship discards my documents, take their documents. Their documents show that the parties were deliberating on the obligations to be performed regarding corporation tax. So, my lord, therefore, my submission will be, if your lordship considers these documents, which are primarily their replies, and one letter of mine which has also been replied to by them, then from that, the existence of the agreement, non-performance of the obligation, and my continuous follow-up to make them perform their obligation so that I can perform my reciprocal obligation is emanating. Just for just once, I may just show once is. So, my lord, this I think, my lord, I rest my case on this, my lord. I rest my case on this, my lord, and I'm submitting, my lord, the finding which has been arrived at by the learned trial court, my lord, particularly with regard to this readiness and willingness, my lord. These are the 4 grounds which has been summarized here, page 142 of the impugned order. Now, your lordship will kindly see once page 142. The agreement for sale is not considered, not on a factual aspect, but on the ground that it is unregistered.
Yes, that you have already submitted today. So today you have given one judgment on readiness and willingness. Submission based on section 49.
Not only readiness and willingness.
Section 14, submission based on section 49 you have made, and you want us to admit certain documents in additional evidence which you say are admitted, which are not disputed. Yes, that is all. The
Ground is, as your lordship has also pointed out, that the agreement itself has not been proved by any of the witnesses. It was tendered by the plaintiff's witness number 1. It was not tendered by the plaintiff's witness number 2. And while the document was being tendered by the plaintiff's witness number 1,
Sorry.
the question was objected to. And it is recorded in the deposition, it is recorded.
Show us.
Yes, it kindly takes the deposition of the plaintiff's witness number 1 at page 20 of the second volume.
Page 20.
Page 20. It starts from page 19. May I read from the very beginning, page 19? My lordship has found page 19.
Yes.
My name is such and such, Ajoy Kumar Saha. He is the plaintiff. I am the plaintiff of this suit. I have filed this suit in respect of such and such. Defendant number 1 was the owner in respect of half share in the suit building. Jharna Sen was owner of remaining half share. She died in month of July 1981, leaving behind such and such. Then, my lord, kindly turn over the page. Further examination in chief of PW1. I am the tenant in respect of the suit property since May 1992. Kindly, my lord, skips over the first paragraph. The second and third paragraph I'm relying on. Second paragraph. There was an oral agreement between myself and the defendants on 1st August 1993 for sale of such and such. This question is objected to. Lordship may kindly note. The last part of the sentence, bracket, within brackets, objected to. Now the third paragraph. On 25th August 1993, this is the date of the agreement which the plaintiff seeks specific performance of. On 25th August 1993, defendant of this suit executed deeds of conveyance in my favor in respect of roof of the 4th floor and 5th floor terrace. So far as share of Srimati Sen is concerned, it could not be registered as she died prior to the execution. I have filed title suit which is pending prayer for decree for specific performance of the contract. Defendants agreed to sell the remaining portion of the property and also executed a deed of agreement on 25th August 1993. And the consideration of the remaining portion of the building was fixed at rupees 35 lakhs, out of which I have paid 25 lakhs to the defendant. 3 copies of the agreement dated such and such was prepared. It was settled that 1 copy of the agreement would be kept under my custody, another copy would be kept under the custody of the defendant number 1, and the third could be kept under the custody of the family members of A.N. Sen. This is objected to. Defendants did not perform their part of contract in terms of the agreement. They agreed to sell the property free from all encumbrances, but the defendant did not clear up the municipal tax. They also did not obtain any clearance. Then the fourth paragraph travels to a different context. Now, my lord, in this the deposition of the plaintiff's witness number 1, lordship will not see that the plaintiff's witness number 1 has ever proved any of the signatures in the agreement. Different plaintiff's witness number 1 is only saying that the document was prepared. And this is especially when the document itself is disputed by the defendant in the written statement and also in one of the letters which has been annexed with the application under Order 41, Rule 27. I will show, my lord, from page 54 of the second part of the first volume, the defendant's letter, the defendant's advocate's letter, where it is being said that there was an agreement of 25th August 1993, but that was a separate agreement. That was an agreement to sell the property at a consideration of 57 lakhs. Whereas the agreement which the plaintiff seeks to rely on in the letters, that fixes a consideration of 35 lakh, which the defendant's advocate had said at that point of time that this is a forged and fabricated agreement. So it can't be the case of the plaintiff that the agreement of which specific performance is being sought is an undisputed agreement. Firstly, the agreement has not been proved by the plaintiff's witness number 1. And I'll also show the deposition, the evidence of the witnesses number 2 and 3. Witness number 2 was the advocate, 3 was the clerk of the advocate. And none of them proved the execution of the agreement. They only say, yes, the document was prepared. Now, kindly turns over at page 22. The examination further continues. Now, in page 23, it is, I think, incorrectly recorded as further examination of examination in chief. It ought to have been cross-examination because it starts with not a fact. Perhaps it's a suggestion given by the defendant's advocate in cross-examination. It ought to be cross-examination. May I place the cross-examination of the plaintiff's witness number 1? Witnesses number 2 and 3 have not been cross-examined. That has been recorded in the deposition. But 1 was cross-examined. Not a fact that I have, page 23. Not a fact that I have filed this suit against the defendant in order to grab somebody else's property. Not a fact that in collusion, I did not give the clear, definite, and complete description of the suit property. Not a fact defendant number 1 became sole and exclusive owner of the suit property. Not a fact purchase deed standing in the name of Jharna Sen is a Benami deed. A.N. Sen, director in charge of the defendant number 1, talked with me, such and such. Then, at the next page, it does not relate to the agreement in question. It travels to various other factors. Now, it kindly turns over to page 28. Page 28 is a part of the cross-examination of the witness number 1. The second sentence, not a fact that such payment of huge amount of earnest money, rupees 25 lakhs, without a money receipt considered conceivable. It was a suggestion given by the defendant's advocate that there was no payment made. Then third sentence, not a fact that I had not paid a sum of rupees 25 lakhs to the defendant. Specific suggestions were advanced to the witness number 1. Then fourth, not a fact that a person cannot pay such huge amount of rupees 25 lakhs as earnest money without receiving possession. Then fourth sentence, fourth paragraph, last sentence, not a fact that the agreement is created for the purpose of this suit. Specific dispute, specific questions asked in cross-examination. Not a fact that there was no oral agreement between myself and Srimati Sen. The last paragraph kindly notes. Not a fact that the aforesaid oral agreement or written agreement dated 1st August 1993 is not still in operation. I do not agree that the agreement is definitely imaginary and figment of fantasy. Excepting the agreement dated 1st August 1993, there is no other agreement in respect of the suit property. The witness says that except an oral agreement of 1st August 1993, there is no other agreement in respect of the suit property. Whereas in the plaint, it has been alleged that there is an agreement of 25th August 1993. Then, it travels to page 29, second paragraph. Not a fact that I have stolen another agreement. I do not agree that they informed the matter to the concerned police station and to me, and the earnest money has been forfeited. Excepting the agreement dated 1st August 1993 in respect of the suit property, there is no other agreement between the parties. Repeatedly, the witness is saying there is no other agreement except an agreement of 1st August 1993. Then, page 30. Again, suggestions given, denied, to the effect that there is the agreement is not manufactured or not forged. And the second last paragraph of page 30, another suggestion, not a fact that the agreement dated 25th August 1990, which would be 1998, has been manufactured and created fraudulently by practicing fraud to grab the property. Not a fact that I do not pay earnest money of 25 lakhs to the defendant without money receipt. These suggestions and these questions in the cross-examination, they are repeated time and again, and the plaintiff denies all those suggestions or all those questions. So, my lord, it can't be said. And my lord, on top of that, the plaintiff's witness admits that apart from 1st August 1993, there is no other agreement. So there cannot be any existence of the agreement of 25th August 1993, even as per the evidence of the plaintiff's witness number 1. That is insofar as the plaintiff's witness number 1 is concerned. He does not prove the signatures, he does not prove execution, he does not prove preparation. He is faced with questions in cross-examination with regard to the forgery and manufacturing of the agreement. So it cannot be said that the agreement itself was undisputed. Even if the impugned order or the impugned judgment proceeds on the basis that the agreement was admitted, but it is not admissible in evidence, then also, my lord, I have the right to challenge those findings of the trial court, even if I have not preferred a separate appeal. That your lordships are aware, my lord, Order 41, Rule 22, that the findings which are against me, I can also challenge, even if I have not preferred a separate appeal. Now, my lord, this is insofar as the plaintiff's witness number 1 is concerned. Now, kindly seize the evidence of the witness numbers 2 and 3, which your lordship will find in the first volume. And he takes the first volume, page 103, which my learned senior friend has also placed. Page 103. But after the first 2 lines,
yes,
I am a practicing advocate in these courts. I know the parties to the suit. I am also aware of the subject matter. I am aware that such and such Lansdowne Road is between my dint of 2 deeds. There are 2 deeds. It was prepared in my office and in my presence under my instruction. I drafted it and signed on it on that effect. I drafted, I signed. This deed is for the deed for sale agreement for the building thereon, excluding the top floor. I cannot recollect about the payment of consideration money. Later, one endorsement it was paid in my presence is on the deed. Yes, the mother deeds were presented to me for preparation of this deed. Yes, also caused investigation of title. The sale was not completed. I was not representing any suit. None is there to cross-examine. So what the advocate does is only to say that he prepared and he signed on it. It is not that he is proving the signatories or the alleged signatories of the agreement. So again, the witnesses numbers 1 and 2, they could not prove the agreement at all, or there is no attempt to prove the agreement at all. Now, my lord, kindly turns over the page 105. This is the third witness of the plaintiff. Page 105.
Who is he?
He is the third witness, is the clerk. Yes. What he is saying, if I may place the short evidence, 1 paragraph. I am the third paragraph of page 105. I am the clerk to a practicing advocate in these courts. I worked under advocate Somorendra Nath Bishwas. He is no more in this world. I also know him as I was his student in Jogesh Chandra Law College. He was also a professor. I have done nothing in the alleged transaction, but I remitted the articles under his instruction. Some letters tendered, these letters were drafted by him, prepared under his direction and signed by him, all in my presence. He was an advocate for Ajoy Babu. The P receipts are annexed. None is there to cross-examine. There is again no attempt to prove the agreement itself. So the agreement has not been proved in accordance with law in any manner whatsoever. Now, my lord, Lordship may kindly note that that only a photocopy of the agreement was tendered in evidence. The original agreement was not tendered in evidence. Now, in that event, the agreement ought to have been proved. But that is what transpires.
Original is in the records.
That is a photocopy of the agreement. That is by instruction.
We have seen, the Lordship has seen the agreement on the last occasion.
No, it has been marked as exhibit. There is no dispute about that.
Give the records.
Exhibit file, give the exhibit file.
Original agreement. My instruction was otherwise, but very well. But if it isn't the original document, my submission was, even if the document is marked as an exhibit, does not dispense with the proof of the document. Mere exhibiting a document would not amount to proving the contents or the execution of the document. On that, my lord, I'll show my lord one decision which says that mere exhibiting a document will not amount to proving the execution or the contents or that the document is genuine. That is the first leg of my submission. The second part is that the letters which your lordship has also seen, that the tenure of the agreement, the alleged agreement, was 1 year. Now, in order to prove readiness and willingness, it also fell from your lordship on the last occasion that what steps did the plaintiff take within that 1 year to pursue the defendant to execute the deed of conveyance or perform the obligations of the defendant under that particular agreement. Now,
yes, to that his response was that 1 year would start only after the obligations were discharged by you.
Yes, that is
Not
the
prior to that.
Yes. In support of that, the decision has been cited. But in this decision of the Supreme Court, that is reported. No. Decision was of 2022, volume 14 SCC 793. I'm so sorry.
We'll continue tomorrow. Hopefully tomorrow it will be over.
Yes, absolutely.
But can it be next week or not? Or is some difficult?
Just take down the learned advocate for